Good morning, everybody. It's good to see very excited Yandra. Very excited faces out here, and we are really raring to go. I can see a lot of discussion happening around our group walk. So brilliant. We'll get right into it. And we'll have Mr. Amannath, our team member, who will be giving a brief recap on what we did yesterday, as well as a little bit of a summary of the discussions held. Mr. Amannath.
Thank you, Harshana. Good morning once again, ladies and gentlemen. I said good morning. That's better. Now, before we commence with the panel discussion proper for day 2 and final day of our multi-stakeholder dialogue on electoral reform, I'll give you a recap of yesterday's proceedings for the benefit of all and to ensure that there's continuity from yesterday's sessions to today's panel discussions. And also, we would at this stage, I also like to welcome some new participants who have joined our program here this morning. We welcome you to our day 2 of the multi-stakeholder dialogue on electoral reform, and we welcome the new participants who have conversed today. So, without further ado, yesterday's program commenced with an opening ceremony, and whereby the opening remarks were delivered by Mr. Nilesh Lal, the Executive Director of Dialogue Fiji. Mr. Lal opened the event by stressing that electoral reform is among the most consequential types of reform that the country can undertake. And it is not merely a technical exercise, it is a process that defines the political architecture of the nation. That is what he had emphasized in his opening address. And he also talked about fairness, inclusion, transparency, and good faith as essential principles for reform. The need for meaningful public engagement, he added, citing the 1997 Constitution making process and the National Council for Building a Better Fiji as historical examples of participatory reform. There was also consensus over the low public engagement during the recent Electoral Law Reform Commission undertaken consultations, and he hoped that this dialogue would raise the quality of national discourse and make a meaningful contribution towards this reform. So that was essentially the gist of what he had delivered during his opening address. Moving further the keynote, and then we had the Permanent Secretary for Justice, Madam Permanent Secretary for Justice, Ms. Selina Kuruleda, who delivered her keynote address as the chief guest in yesterday's event, and she also cited the need for continued engagement and contributed and also thanked the Dialogue Fiji for converging this national conversation, whereby they could discuss the need for reforms and and for inclusive participatory contributions from all the stakeholders towards this critical national reform. And then we had an presentation by Mr. Alan Wall, a globally renowned electoral expert. So his theme was titled the trends in electoral reform, and are these ideas relevant to Fiji? So he delivered he highlighted the global trends in electoral reform that are relevant to Fiji, emphasized that reform must be context specific, and not all changes truly qualify as true reform. So key priorities include restoring trust in electoral processes, promoting inclusion and participation, and ensuring that there is fair political competition in informed voting. And he also stressed the importance of timing, citing international standards and that discourage changing less than a year before an election. And making 7th August 2025, which is in 2 months' time, a critical deadline for Fiji. Globally, there's been a shift, added Mr. Wall, shift from plurality systems to more proportional systems, like the open list proportional representation to mixed member proportional representation system, to reduced waste votes and enhancing voter choices, added Mr. Wall. The other key salient points included the need to include women, youth, and persons with disabilities in the electoral processes, improvements to voter registration systems, and regulating campaign practices and AI used to protect electoral integrity. So, ladies and gentlemen, that was essentially the key salient points that was emphasized by Mr. Alan Wall in his deliberations yesterday. And ladies and gentlemen, we also had a presentation delivered by Professor John Frankel of the Victoria University in Wellington. He's a professor of comparative politics at the Victoria University. So he also delivered a presentation, and some of the gist of his presentation included was focused on designing electoral systems and constitutions for divided societies. So he, whilst commencing his while he commenced with the presentation, he posed a question: is there an ideal electoral system? Professor Frankel argued that proportional representation systems work best in the context of divided societies like Fiji. In Fiji, he argued that majoritarian systems or laws tend to encourage too large ethnically based parties. So they, Spain, the evidence, a PR system works best. So he explored the characteristics of the respective electoral systems in different country contexts, namely the majoritarian first past the post, the open list proportional, the closed list PR system, and the mixed member proportional representation system. So explored the different dynamics of the respective PR systems. He also examined the implications of electoral systems in addressing ethnic conflicts in countries such as Fiji, South Africa, Bosnia, and Northern Ireland, to name a few. So that was the gist of presentation by Professor John Frankel yesterday. And following lunch, we had a panel discussion on the themed political party insights, challenges, experiences, and reform priorities. That session on political parties was moderated by Dr. Shailendra Singh, Associate Professor and Coordinator of Journalism Program at the University of the South Pacific. So essentially, the panelists included Mr. Wilame Takayawa, the General Secretary of the Social Democratic and Liberal Party, SODELPA. We had Mr. Savanatha Narumbe, the leader of the Unity Fiji Party, and Mr. Satish Kumar, the Management Board member of the Fiji Labour Party. So essentially, the three panelists, discussed, they deliberated on the perspectives of their respective political parties' viewpoints on the current electoral processes, the need for inclusivity, and the need for better outreach. And they also highlighted that they already made submissions to the Electoral Law Reform Commission, and they provided their viewpoints on the current electoral law reform processes. Mr. Narumbe, the Unity Fiji leader, the leader of the Unity Fiji, also questioned as to why rush the electoral system, the processes towards the electoral system. He also cited that the need to proceed with reforms just after elections, and these drawing too close elections. He also alleged that the media were not running stories that were highlighted by the party, to which Dr. Singh allowed the responses from the media organizations who were present here to respond to to remarks by Mr. Narumbe. And there was great level there was great enriching discussions during this yesterday's session that concluded with the panel discussion. And we had the last session for yesterday. We had the breakout session whereby participants deliberated on they had a group discussion to review the Electoral Act of 2014. So the group was to identify the shortcomings and propose reforms. And at this juncture, I kindly remind the participants that you please be ready with your presentations, with your key presentations for the breakout session post lunch. So we look forward to your deliberation and hope that you had worked on that last night. as you had promised yesterday. So we look forward to that. So, ladies and gentlemen, that concludes the today the recap for yesterday. And without further ado, I would like to now call on the moderator of the next panel discussion for today's session, which is reforming the legal framework from critique to proposal. And the moderator of today's panel discussion is none other than Mr. Alan Wall, the a globally renowned expert on electoral system design. So, Mr. Alan Wall, the floor is yours to proceed with the next deliberations. Thank you.
Thank you, Aman, and welcome everyone to the second day of the workshop. We're running 15 minutes late. We're still going to have the 45 minutes that are scheduled for this session, but to make sure that we can actually fit all the comments in, I'm just going to very, very briefly introduce the people that are on this panel with me. The panel today, yesterday we heard from political parties on what they thought their priorities were for amending the law. Today we're hearing from elements of civil society in Fiji about what they see as the issues that need to be dealt with. On my immediate left, we have Professor Shaista Shamim. She is Vice-Chancellor and Dean of the JDP School of Law at the University of Fiji and a Fellow of the Royal Society of Arts. Former Ombudsman, Chairperson Director of the Fiji Human Rights Commission, substantial positions in the legal fraternity, education sector. More interestingly, she's been a filmmaker. That must be much more interesting than being an academic. As you can see here, she's highly academically qualified, worked for the UN Human Rights Council as a special rapporteur and an award winner for the WISPAC Fiji Business Executive of the Year, Professor Shamim. Next to her, we have Nilesh Lal, who I'm sure none of you know at all, so I have to give a really, really long introduction for what Nilesh does. He's Executive Director of Dialogue Fiji since 2014, done a lot of research, work on democratic consolidation, electoral processes and social cohesion, and most importantly, organising things like today, promoting inclusive dialogue, and fostering democratic values, getting people involved in determining what the future of Fiji's democratic process will be. He's also a board member of the Tertiary Scholarships and Loans Scheme. And as you can see, also a highly academically credentialed person. Lastly, at my extreme left, we have Mr. Stanley Simpson, Director of MAI TV and Secretary of the Fijian Media Association. He's Director of Media Production House, Business Media, Editor of monthly magazine Fiji Plus, an award-winning journalist with over 20 years of experience in Fiji and the region, and a board member of the Pacific Islands News Association. As you can see here, he's got extremely deep experience both in print and in audiovisual media, and delved in a range of fields from civil society, media, corporate communications, and as a media entrepreneur. So I'd like you to welcome the three members of the panel, please, for this discussion. Hopefully we will have shortish presentations, so there's plenty of time for questions of them afterwards. We have 45 minutes, and I'd like to hand the floor over to Professor Shamim.
Thank you very much, Dr. Wall.
Not a doctor.
Oh, sorry. Okay. Well, let me give you that title then. Thank you very much for that introduction. Thankfully, it was short. And I want to say Yandra Vinaka to everyone, and namaste to Mr. Kumar and Mr. Balwant Singh I see sitting there in the audience. And also, good morning to all of the representatives of the various political parties and institutions. I don't know you all, but thank you for being at this session. And of course, PS most of all, Madam Law and Justice. So really the title is apt there for sure. Like the moderator said, we want to keep this short so that everyone has an opportunity for discussion. And I want to start with a bit of a challenge. We've been told all along that, this is, we are discussing what is electoral reforms, that might be electoral reforms in a conflict ridden and divided society. And really, I think we should stop thinking of ourselves as being conflict-ridden and divided. We start with words. I think language is extremely important. And if we say we're a diverse society rather than a conflict-ridden and divided society, then we're much more likely to make inroads into what constitutional and electoral legal changes that we want to make, because I'm an optimist by nature, you can tell. And I don't really want to be constantly told or shoved down my throat by whoever that you're a conflict-ridden society and therefore you've got to do your electoral reforms or constitutional change in that way. Of course we are diverse. We're a multicultural society, we're a multilingual society, and we have a whole lot of different diverse positions on politics, the social milieu, economics, and just about everything. Gender is very important, and I will refer to that in a minute. And we have diverse positions, and we are diverse people. So I would really like, that's not to say we're not going to have electoral problems, that's not glossing over the issues that we might have, but I think if we put a positive spin on it rather than a negative one, we're much more likely to make inroads, because otherwise we keep believing that we're a conflict-ridden society and we've got to find solutions to resolve the conflicts. But in fact, we know that, I get on with the person on my right, and I get on with the person on my left, and I get on with the two lovely people sitting here in the front. What conflict? Everything can be talked through and negotiated if you run into difficulties, like if you have different positions. And that's basically from our human values approach, and I need to bring in the University of Fiji here because I am representing the University of Fiji. From the human values approach, that is exactly our position at the university. And we have diverse peoples at the university, both students and staff. And we prefer to dwell on the diversity that we have as a positive thing rather than the conflict we might have every now and then, because we're human too. And so that, we resolve those through mediation, through negotiation, through the legal system if you want to, if you really can't get on. But at least we're still talking and having a conversation with each other. When we're talking about conflict, we really talk about the fact that we cannot no longer communicate. And I really, at my age, and experience, I feel that that's not true at all for Fiji. So diversity is what I want to emphasize in my talk, and hopefully in a short way, as I've already been asked to do. Now, the first thing that I want to say is that the University of Fiji prohibits direct or indirect discrimination on the basis of and I'm reading this from our human resource policy document, on the basis of actual or supposed personal characteristics or circumstances, including race, culture, ethnic or social origin, color, place of origin, sex, gender, sexual orientation, and gender identity and expression, apart from birth, primary language, and all the whole gamut of things that you will find in the Constitution. Now, this isn't something that just occurred in the 2013 Constitution. All the constitutions of Fiji from 1970 onwards emphasized equality of treatment, equality of employment. You cannot discriminate fairly or unfairly on the grounds of anyone. And it was only in the 1997 Constitution the notion of unfair discrimination came in. So for a long time, 10 years in fact, while I was director of the Human Rights Commission, we closely monitored what the difference was between fair discrimination and unfair discrimination. And really we came to the conclusion that fair discrimination is if somebody who is visually challenged wants to get a driving license and drive a car, then that would be fair discrimination if you would not allow him to get a driving license, or her, because otherwise he or she would be a menace to the rest of the population. So it's a balancing exercise between stopping people or allowing people to do one thing and balancing it out with public interest on the other, as long as that difference is reasonable and justifiable, or the different treatment is reasonable and justifiable. And I think that's a really solid piece of law that has remained in our constitutions and started off in 1970, was there in the 1990 Constitution, was retained and expanded in the 1997 Constitution, and continues in an even more expanded way to include gender identity and expression in the 2013 Constitution. So when we're talking about reserved seats in Parliament for anyone, and this is my next point, you have to be very careful as to on what basis do you want to reserve those seats. In the past, during, when we had a 1997 constitution, and we also had a separate house, the upper house, the Senate, you had separate seats reserved for different ethnic groups and the Council of Chiefs and other interest groups. In order to be able to fill those seats, those reserved seats, you would have to identify yourself as that person or coming from that background, am I right? However, if you're going to have reserved seats for women, are you sure that you know what the definition of woman is? In our transgender world, which is the 21st century world, there is no clear definition. It is a self-defined concept, quite often. And if you're going to have reserved seats on the basis of gender expression or on the basis of sex, identification of sex, then you had better prove that you are of that category. You should be able to prove it. Now, how do you prove it? Well, I leave the question to you. With difficulty, how would you examine it? So if I, for example, am sitting here and you would presume that I am a woman, tell you that I'm actually a man, how would you know the difference? Just looking at me isn't enough anymore. So we as people at the university who cherish and respect and protect diversity say that if you're going to be reserving seats for anyone, then you'd better find out who it is that you're reserving seats for, that you're bona fide, that they are bona fide, the person of that category that they're claiming. And that's all we say. We're not saying that reserved seats necessarily, we are against reserved seats anyway. We don't think this should be special treatment for anyone. So, but if you are going to do that, and if the populace decides, and the civil society people sitting here, and the political parties and so on, decides, oh no, you must have reserved seats for someone, then you better open the door to reserved seats for everyone, for whatever category that you'd like to call yourself. And I think, that's really, we need to be very sure that we're acting with our brains and not just with our feelings or our passions or our beliefs, prejudicial beliefs or our biases. So that's the first point I want to raise, that if you're going to have electoral reform with seats reserved for anyone, then you must realize that, especially if it comes to reserved seats for women, that you're going to be coming into a whole lot of difficulties, because I know from being the Vice Chancellor of a university with very diverse sexualities expressed at university amongst the student population, but also the staff, and I think those of you who are at university know this as well, we really cannot ignore, and by ignoring we're actually extending the prejudice that society might hold against those people. Now, as I said before, the 1970, 1990, 1997 constitutions, and as well as the 2013 constitutions, all protected people from discriminatory behavior and practice. So whatever electoral reform or change of law that you have, you must be sure that it is not discriminatory, that just because you're expressing your sectorial interest, which you might be as a minority group or as a special category of people, that you're not actually discriminating against someone else by doing that. And I just refer you to the sections of, I think you can do further work on this, but if I can refer you to the 1970 Constitution, specifically Section 3, prohibits discrimination on the grounds of sex. 1990 does the same in Section 4. 1997 does the same and expands discrimination on the grounds of sex and discrimination on the grounds of sexual orientation. That is the additional point in Section 38 in 1997 Constitution. And in the 2013 Constitution, we have Section 26, which expanded the category of sex, gender, sexual orientation to sexual identity and expression. In other words, you cannot discriminate against anybody if they suddenly stand up, like if Stanley stands up here and says, I'm a woman, you can't discriminate against him or her, / Yeah. Okay, now my second point, very quickly, Mr. Moderator, is to do with constitutional change and the link between the constitutional change that everyone's talking about right now because it's gone to the Supreme Court and electoral reform. Everyone will know by now that there's been 5 questions referred by the government to the Supreme Court. I'm not really that concerned about the first 4 questions, but the 5th question, which apparently came in from left flank, to use the rugby expression, is whether the 1997 Constitution is still valid and applicable. That's the last question. And Honourable CJ has said that that's the spanner in the works. And it's true, because when I looked at the 4 first questions, I thought, yeah, all right, we can handle that. But the 5th one is a very important one, because how are the judges to rule on that? Judges have to determine that. Now, if the judges say yes, that the 1997, the answer to that question, is the 1997 Constitution still valid and applicable? If the judges say yes, this will be the effect of that declaration. This is a declaration, right? It's not a decision as such. You can say that we don't really agree with declarations, but we have to, because judges' pronouncements are very weighty. Being a lawyer myself, I know how weighty they can be. And you know, if you look at what's going on in the United States right now, with Trump and so on, where every time Trump tries to do something, the judges thwart him, and the term judicial coup is being used in the United States. We may not necessarily agree with either Trump or the judges, but the word judicial coup, which I've never heard before in the whole separation of powers doctrine, because judicial pronouncements are so final, but a judicial coup is something that I think that we should put in the mix right now. So assume that we don't know which way they're going to rule, but the question of is the 1997 Constitution still valid and appropriate, if we assume that they will say yes, if they say no, no problem at all, right? The 2013 Constitution prevails. But if they say yes, then clearly the electoral laws will have to change in order to comply with the 1997 Constitution on electoral provisions. And moreover, the Senate, another new house, will be established, because the 1997 Constitution has that. That means there is no way the electoral reforms, and I'm talking about the fact that it is already before the court right now, those questions and that particular one, but there's no way that the judges, well, they might pronounce on this by August, and I have no doubt at all that they do it really fast, but once that takes into effect, how long is it going to take to change everything, to go back to the 1997 Constitution provisions on electoral reform? It certainly is not unlikely to take place within a year, because not only do you have to look at establishing the Senate, you also have to look at reforming a whole lot of electoral laws that, you know, the Dialogue Fiji and ourselves have made submissions on to the Electoral Reform Commission. So that's going to take a long time. Now, one must know that elections can be deferred as a result of that work needing to take place. Now, you might say that, oh, well, you can't really defer the elections, you know, they have to happen by August 2026, but actually under the 1997 Constitution, elections were deferred. We didn't have elections for a long time until 2014, so it can under the 1997. Under the 2013 Constitution, it can't be deferred. And I checked both provisions last night just to make sure. So under the 2013 Constitution, you really cannot defer the elections. It says the term of Parliament is 4 years, full stop. Right? Under the 1997 Constitution, of course, assuming other things may take place, you can defer. So you could defer ad infinitum until somebody decides, yeah, we're ready to go into elections, and goodness knows what can happen in the meantime. So that's number one effect. Number two effect, if the 1997 Constitution comes back into being, let's say if the judges declare it, then you must realize that the immunity provisions are really important and key to that. Under the 1997 Constitution, the 1987 people still have immunity, but not the 2013 people, or 2009 people. No, the question is about 2009, not 2006. So that's a reference to the Supreme Court. So, you know, one lot of immunity drops, but 1997 immunity remains, and you will know what the impact of that will be, all right? Instability is what I see happening. So decide, as political parties sitting in the room, and NGOs and stakeholders and academics, of course, but academics have less influence. Well, some academics have less influence. What you want to do. You need, when you do your resolutions at the end, I think it's really important to take that into account. Next thing I want to dwell on very quickly is the media, the role of the media. Somebody brought up, I think it was Mr. Narumbe yesterday, said, oh, look, when we send out news, they don't even publish it, and they have a bias and all the rest of it. Actually, my policy, and by the way, let me tell you, which wasn't on my description over there, is that my very first job after university was as a journalist in the Fiji Times. So I did not get any fancy journalism and media degree or anything. I was trained in the newsroom by eminent journalists like Robert Keith Reed, Shona Smiles, Vijay Kumar, and others, the best in the business really at the time. And I know exactly, that was 1976, and so I was there when 1977 happened. Some people might consider 1977 to be a coup, the first coup perhaps in post-colonial Fiji, because you remember that NFP won the elections and then were quickly shunted to the side and a caretaker government appointed. And then, or an interim government, whatever they call. And then we had another elections in September, and of course NFP being split in the middle, never came back again as government. So I was there in 1977, and I do recall sitting in the newsroom while, Vijay Kumar comes rushing into the newsroom and says, recall Koya's, the picture with the Koya, the newspaper edition with the Koya's for PM in the front. Quickly, he's no longer PM, it's back being Ratamar again. And that was really quite a shock to the system. As a 19 or 20-year-old, I was at the time, 22, I was thinking, goodness gracious me, is this how it all works? And in the newsroom, a rookie journalist, in the Fiji Times, respectable media organization. And I also remember something else which is much more horrific, and I don't want the media to report this, so this is, secret. I remember I was sitting there, stunned as a mullet, and one of the journalists, senior journalists, walks right in, stomping in, and says, after Koya had gone off to a government house to be sworn in as Prime Minister, because he was turned around and sent home again, but said, bloody Indian government. Bloody Indian government. That word, that phrase stayed with me forever. And it called into question the media, the role of the media. It totally did for me. I was disillusioned, disenchanted. I thought we had to leave our political biases and prejudices and whatnot at the door. But that wasn't the case. These are the people who trained me as a journalist, and I lost faith at that point in the media. But I struggled with it, and I stayed, and then I went on and did other things. But now, of course, I say to Mr. Narumbe, don't chase the media. Let them chase you. That's rule 101 for teenagers anyway, right? You want something, don't chase them. Let them chase you. And that's what I say to Mr. Narumbe, And number 2, develop your own press corps. It's very important that you have your own media presence. Now, with social media, it becomes even more important, because social media means that you can bypass the mainstream media and you can go right ahead and you can publish anything. Of course, somebody will come back and say fake news or whatever. Make sure, if you're doing it, to be honest and above board, and don't make up stories. But report on your stories. Give your facts out. Put your news out. That's what we do at the University of Fiji. We have our press corps is sitting there right at the back. Both established journalists, and that's what we do. We make our own news. We have our own radio station. We have our Uni-Fiji Watch, which is a student newspaper. So it's really important. And one last point, very small point, and that is, unfortunately, Wiley Clark is not here from the Fiji Law Society. I've been hearing too much about this thing called rule of law. And I heard a recording, now it's on social media, so it's in the public domain, so I can talk about it. I heard a recording where a bunch of lawyers went over to an institution, and they were recorded by the investigating officer, now I'm not going to say anymore, and it's out on the social media, so I heard it, and they said, oh, you've got to understand the rule of law, saying to the previous FICAC commissioner, you've got to understand the rule of law. This is not the rule of law, and on and on and on. And I'm saying, are these people really talking about the rule of law? They don't even know what the rule of law means. So I'm asking the Fiji Law Society to have a seminar on the rule of law, because I think the concept of the rule of law is as slippery and slidey as the concept of gender. And so if you're going to be changing electoral reforms in any way whatsoever, first of all, you understand the foundations of what rule of law actually means, and it may mean different things to different people. Those who want to uphold the law, rule of law may mean something. Those who want not to uphold the law, those who want to carry out nefarious projects, and divide society more, create more conflict, they'll have a different concept of rule of law. Those who want to protect themselves and their previous, whatever they did, they may have another concept of rule of law. So be very cautious. The lawyers, I tell everybody, how many lawyers in this room, be very cautious when you use the word rule of law or the term rule of law, that you know what you're talking about. Thank you so much. I'm sorry I've taken a bit more time than I ought to have, perhaps. Thank you.
Thank you, Professor Shamim. I think critical issues there, this whole issue of constitutionality is something that's going to be so critical over the next few months in this country. I'd like now to ask Mr. Nilesh Lal to make his presentation. And are you going to use PowerPoint for this? Okay. Can we keep this, again, relatively brief, please, Nilesh?
Thank you very much, Chair. So I'm going to be examining the criticisms, and this will include some of the myths that have been lingering in the public debate on electoral system, on Fiji's electoral system, and then what are some of the reform priorities that we see in the current context. So Fiji, as you know, has used mostly majoritarian and plurality systems for most of its national elections. The plurality system, first past the post, was the one that was used for elections held in 1972, 1977, 1982, 1987, 1992, and then 1994. After that, there was a move to a majoritarian system, so we adopted the alternative voting under the 1997 Constitution, and there have been 3 elections held using the alternative voting system in 1999, 2001, and 2006. Then we made a departure, embraced a proportional representation system for the first time, and 3 elections have been done using the system, 2014, 2018, and 2022. Proportional representation, which is the system that we have been using since 2014, is the most popular electoral system in the world. So 38% of 217 countries use a form of list PR. And of all the countries considered democratic or free, more than a half, 53% use a form of PR, 33% use majoritarian systems, and 14% use mixed system. So despite the popularity and effectiveness of PR systems globally, Fiji's OLPR or open list proportional system has been subject to immense criticism. So let us examine some of these criticisms that are quite commonplace in Fiji. The first one is the coattail effect. Some people have called it the rockstar effect. I think it was Professor Rathuva that popularized this phrase in Fiji. And the current chairman of the Fiji Electoral Reform Commission has used the phrase big man syndrome. And the argument is that this makes the system undemocratic, and that democracy is distorted by it. The reality, however, is that coattails are natural in OLPR systems. A popular leader brings in votes that benefit the party list, and it is not democratic. It is proportional representation in action. So it is a feature of proportional representation. Closed list systems have a similar but hidden effect and have a much lower level of candidate accountability than OLPR. So closed list system is also of interest to Fiji. It has been proposed, or it was proposed in the Ghai Draft Constitution of 2012. So what is important to note here, that if we did adopt a CLPR system, then we would be taking away voter agency. So voters will no longer decide who from the party will get elected into the legislature. Instead, it would be the party leadership that would be making the decision. So that is going to further amplify the effect of the big man, the party leadership. In the previous system that we had, the majoritarian system, it was also the big man or the party leadership that was essentially calling the shots by allocating safe seats for the party to candidates of their choice. So it is in fact the current system which is taking the agency away from the big man, in contrast to all the systems that we've used since independence in system. So can you see, this is essentially a myth that has been perpetuated by those that are opposed to the current system, but it does not really have a factual basis. Next. The second myth, and I think one of the party representatives also echoed similar sentiments yesterday to one that is pretty popular in the public debate on Fiji's current electoral system, is that candidates with fewer votes are getting elected and those with more are getting left out. And then they say that this is unfair because people with votes as low as 200, 300 are getting into the legislature and they're getting into government, they are getting appointed as ministers. Now let's examine the facts relating to this. In OLPR, seats are distributed based on party vote totals and then ranked by individual votes within parties. So when it comes to seat allocation, there are two steps that are at play. Initially, it is determined what proportion of the total vote has been achieved by that party. And then, the second step is to determine the ranking of candidates within the party list. And then based on the number that has been owned by the party, then people or candidates from that party get a seat into the legislature. So it is important to point out then that in a PR system, it is proportionality between parties and not proportionality between candidates that is of consequence. This is of course by design in PR systems, and it ensures proportionality. Next please. The third claim is that previous electoral systems used in Fiji were more fair, they were fairer than the current system. And the claim, of course, is that this led to more representative outcomes. Okay, so just take two examples. FPTP, which is an example of a plurality system, used for the most part in Fiji's elections post-independence. Most of the elections that have been held have used this system. So let's consider this hypothetical electoral district, District 12, right, which uses the first past the post system. And first past the post system, of course, will have a single member. It would be a single member district, meaning that only one person would be elected from the district. That's the thing with the majoritarian and plurality systems. So the election results are as follows. Candidate A has received 49 votes. Candidate B has received 45 votes. Candidate C 40 votes. Candidate D has received 32 votes in this election. Now the result from the district would be that candidate A will get elected with 49 votes. Right? This is notwithstanding the fact that 166 people, which is way more than 49, in the district did not vote for him or her. Right? So 71% of the votes that were cast in that particular constituency or district will find no expression at all in seat allocation. Their voters will have no representation in parliament. So this is the kind of outcomes that happen under majoritarian or plurality systems. Now, under the proportional systems, which is the systems that we have been using since 2014, if we consider a hypothetical district, district 13, the district magnitude, so in PR systems we have multi-member districts, meaning that more than one candidate gets elected into the legislature from that particular constituency. So the district magnitude is 3, meaning that 3 people will get elected from the district. Now, the parties have received votes like in that manner. Party A 49 votes, which is around 26% of the total vote. Party B 45, Party C 40, Party D 32, Party E 21. Right? So in this constituency, in a PR system, you will see Party A will receive 1 seat, Party B will also receive 1 seat, and Party 3 will also receive a seat. Only parties D and E will not win a seat in the legislature. The percent of votes wasted here, that will find no expression in seat allocation, would only be 28%, right? And there would be broader representation, more proportional representation that would be guaranteed. We've seen this happen in the case of Fiji as well. In the 1999 elections, Labour Party received just over a third of the total vote share, and they won more than 52% of the seats, which allowed them to form government essentially on their own. They could have, right? So they won 37 out of the 71 seats in the parliament at that time, which was an absolute majority, and they only polled just over 30% of the entire vote. So this is the kind of disproportionate outcomes that used to result under previous systems, whether it was plurality or majoritarian systems that we have used in Fiji. So as you can see from this example, that that voters for parties B and C are able to elect representatives in first past the post that be left entirely unrepresented. Now let's examine the next myth that is also quite commonplace, and we need to take this head on. That the system was designed to favor the Fiji First Party. In fact, this claim was made by a professor that was invited by the Attorney General last year to speak, Professor Anthony Regan from the Australian National University. He made this claim that the system favored one political party. Now the fact is that the system itself is neutral. Popular leaders exist across parties. All parties have the ability to nominate high-profile candidates. There's no structural impediments at all to any party. So it becomes a matter of strategy if you are able to have a popular candidate. In elections, at the root of it all are, of course, an exercise in popularity, right? So outcomes actually reflect voter choices and not structural bias in the system. Next. The next claim is that the system centralizes power in the Prime Minister and Attorney General. This also was a claim that was made by Anthony Regan last year. Now the fact here is that the power concentration that might have been seen during the time of the reign of the former government, Fiji First government, the power concentration that resulted was due to their party constitution and leadership dynamics, not the electoral system. OLPR allocates seats proportionally, but how power is wielded in government is a separate governance issue, nothing to do with the electoral system at all. The next myth is that OLPR causes low female representation. And I think this claim has been made fairly recently, that few women are elected because of OLPR. Now, if you examine the facts pertaining to this, Fiji had its highest ever female representation in the legislature in 2018 under LPR. You know, the parliament that was retained after the 2018 elections had the highest proportion of women candidates, MPs, in the history of Fiji. If you consider how women representation was under the previous system, it was really, really bad compared to the present one. Right? Globally, there's evidence that systems that the OLPR system used in Sweden, Finland, favor women's election. The issue here lies in party nominations and of course voter choice and not the electoral system. The sixth myth is that OLPR causes weak accountability. And this is something that also has been mooted by the current, the chair of the Electoral Law Reform Commission. Now, if we examine the facts relating to this, evidence shows that non-performing MPs have been voted out in subsequent elections, as shown by the 2014, 2018, and 2022 election results. So, if you analyze the results at the candidate level, you know, unfortunately, they have taken off the FEO app, which was an invaluable resource for doing this. Right? If you use that, then you will see, because it has got historical data, which is very, very important, you know, for any elections related research. You'll have noticed that apathetic MPs, or those that were seen not to be effective, non-performing, were essentially, you know, voted out at later elections. So that will essentially burst the myth that the current OLPR system has no mechanisms for ensuring accountability of elected representatives. The open list system enhances accountability more than closed list or first past the post. In first past the post, even if the candidate is ineffective, apathetic, people with a very strong political affiliation will still vote for them, lessening accountability. And this used to happen in the past, particularly when we had this two-party race under the 1997 constitution. Most people felt they didn't have a choice, right? So they could only vote for FLP. You know, mostly if they were Indo-Fijians, they thought that they only had one choice, FLP. If they were Itoke, they thought they only had one choice, which was SDL. So regardless of who the candidate was within their constituency, they didn't have a choice. So even if the party leadership decided to field somebody, maybe your neighbor who is not on talking terms with you, you didn't really have a choice. If you wanted to vote for the party, you only could vote for him or her, right? And now, under the current system, you know, if you are strongly affiliated to the party, you know, you have 54 other choices. So can you see, it has essentially broadened voter choice. Next. Sorry? Okay. Okay. So maybe we'll come back to that during the discussions. Yeah. Okay. All right. Should I just yeah, so I'll very quickly cover this. I think this is a very important part of the current debate that is being held about this single national constituency that we have in Fiji. It has been very widely criticized, right? So let's, but I have argued, including to the Electoral Law Commission, why this is essentially quite desirable for Fiji. Firstly, it promotes broad-based inclusive politics. It encourages parties to seek support across ethnic and regional lines, incentivizing moderate and inclusive policy platforms. So we need to, if you look at Fiji's history, we need an electoral system that incentivizes, broad-based politics, more inclusive politics, rather than, riots, politicians, candidates, parties that have this very narrow ethnic appeal. It eliminates malapportionment. That was a real problem. The fact that people in different districts, electoral districts, had votes that had varying values. in as far as the final allocation of seats was concerned as well. It eliminates totally the scope for gerrymandering, which is a real problem, particularly under constitutional framework in a political culture where the executive controls everything. So even if you're going to be having a constitutional boundaries commission in future, which is if we revert to the old constituency system, we will have to establish a commission, right, that would be essentially appointed by the incumbent party, and it is going to be drawing up boundaries, which can, to a very large extent, be used to manipulate election outcomes. It ensures proportional representation of minority voices, reduces ethnic bloc voting, and localized communalism. Against these five compelling advantages, the sole argument that has been raised by critics is that the single national constituency weakens voter representative links, and this argument, in my view, is not only theoretically questionable but also empirically unfounded. Empirical research done by John Curtis, who is one of UK's most respected electoral experts, has shown that voter representative links are not inherently stronger in single member districts. So I will conclude here. Hopefully there would be time to come back to some of these issues later in the discussion.
Thank you, Nilesh. Electoral systems are really arcane things. They're very difficult to understand in many ways. And of course, politicians aren't going to like the systems that don't elect them to power. So this is often the basis for criticism of what existing electoral systems are. As I said yesterday, it's a lot easier to see the faults in the system you have than the problems with the ones you don't have. With that, I'd like to hand over to Mr. Simpson. We are behind time already, but please take your time to give your presentation.
I hate to hold people up for morning tea. So, and I'm glad I have to rush through this, because if you can see me typing, I actually was preparing some points as I was sitting up here. Thank you for the opportunity for this. I thought I'd just raise a few points for discussion about how we this electoral reform and how we can improve the electoral system. And a lot of it, in my view, doesn't have to involve legislation. It involves changing our culture, our democratic culture, and our democratic attitudes. But I think there's a real issue we have of having to over-legislate everything in this country. And I always see people turning up to the polling stations fearful about doing something wrong or breaking the law. Because much of the things they've been warned about is, be careful what you come and do here. Instead of them coming in to celebrate their right to vote. So I think that's one perspective that we've got to look at in terms of our legislation or something. Make it happy. It's written in ways that you almost think that when you're reading it, it's almost like, damn, if I'm going to follow this, I'm going to prison. We're following some system that's suppressing. The whole, even what I was reading yesterday, the whole discussion around it is, cloaked in all this bureaucratic jargon and section this, all these kind of things. That just totally undemocratic language. That's one thing that I just want to look at. I'm speaking here just as a journalist and an observer and a participant, and quite a few elections since '99, I believe. There's some laws here. On sections of the Electoral Act criminalizes actions, in quote, that brings the supervisor of elections into disrepute. You cannot write anything that brings the supervisor of elections into disrepute. I mean, what is he or she? Some kind of sacred animal? And who decides, what is disrepute? So, then the language is so vague, but the penalty is severe. Up to 5 years imprisonment and a $50,000 fine. So every time we're writing about a criticism of, say, the supervisor of elections, we're wondering, well, will we get that fine or we'll go to jail or what? So it actually happened in 2022, but many people don't know. The Fiji Times wrote a front page criticism of the supervisor of elections. I think it was by Mahendra Chowdhury, saying that he was basically a power into himself because there was no electoral commissioner. I think he had been resigned or he was no longer there. The supervisor of elections actually called them up and threatened to throw this at him. You're going to go face 5 years in jail or $50,000 fine. Then the lawyers got involved and then they settled out of court. But part of the settlement was that the Fiji Times could not report that they had settled it. Someone told me this, but I can report it because I wasn't part of that agreement. I hope nobody finds me because the law is still applicable, I believe. So it was not used to deter misinformation, it was used to intimidate. So too much power in one person. Commanding the electoral process, issuing orders, public reprimanding everybody. Candidates, media, operating without meaningful institutional restraint. That's just one to think about. The other one is this media blackout, which is an outdated tool in a digital age. Enforced 48 hours before polling. It's designed for an earlier media era in my mind. Incoherent in the execution, discriminatory in impact. Someone wrote this for me. While traditional media silenced, social media platforms, Facebook, TikTok, WhatsApp continued to be flooded with campaign messaging, some of it sponsored and algorithmically boosted. So what resulted is a skewed information environment where the regulated are punished and the unregulated are empowered. So I don't think we can control that now. It's very hard. So persisting with this outdated legislation will only undermine the credibility, elections of office, and the law itself, and it'll make everyone laugh at us. People are going to be posting and laughing at us that we're trying to impose. So try to be relevant to, maybe that's why a lot of young people thinking, what are these people trying to organize us here? They don't know we're living in a different world now. There was an amendment that tried to prevent polling. They said if you want to do polling, you have to first pass it through the supervisor of elections, correct? And then he had to approve the methodology, then you can get to it. How undemocratic, how much more undemocratic can you get there? So that's why there's no polling. So what is democracy if we fear asking people what they think? So if we want political participation to be intelligent and informed, the electoral must have access to independent data, not just curated sound bites. Then a few other things that they tried to do. One, they tried to do a Moodle exam for journalists. I'm not sure if some of you recall this. So they said we had to sit an exam. They worded the thing carefully to make it so that they don't get criticism, that you have to sit the exam and be registered, but the implicit threat was there. So you may not be registered or considered eligible if you don't do the course. So I Googled this morning, and in Fiji Times did an article where he has berated the Fiji Media Association and heads of 3 local media organizations for dragging, this is Ayah Said Qayyum, the former Attorney General, for dragging their feet on attending Fijian elections office training sessions. So the media had asked him about how amendment to media legislation had the potential to cause undue interference into the integrity and independence of the Fijian media. Then he says, how will it affect the media? Basically asked the media again. He said, Stanley Simpson has not even attended the Fijian elections office training session. Here you have the organizations supposedly represent the media, organizations not attending. So, I just want to make that point here. Training is good, but trying to access electoral events and press based on a course is close to licensing journalism, which we should avoid. This created a system where those who didn't comply risked exclusion, not because they were unethical or unqualified, but because they did not submit to bureaucratic vetting. So press freedom cannot be conditional. Then they also tried to set up a Center for Credible Election Information. And they put an ex-FBC reporter in there. Essentially it failed. Look, I think that they meant well. They probably wanted to, create, but this is what happens when you try to impose, control, or manage a situation without consultation, without talking to all stakeholders. I'll round up now, because I'm not short of time. So I think in short, let's write laws that empower citizens, not intimidate them. I think more important than electoral laws, because I see a few political parties here, is actually how political parties engage with the media. Your comm strategy and how you disseminate your points. In 2022, some parties did not want to turn up for an interview to the mainstream media at all. I think you people know which party that is. They did not turn up for any debate. I tried to interview any of them. They didn't turn up to VJ. They didn't turn up to interview to the Fitch Times. They just didn't get involved. They wanted to win it all through social media. And they failed. So, the other thing is, some parties really are not doing, sometimes I can tell you that the media try our best to try and get a debate that we see overseas, but the quality that's coming from the parties is just not there. You're having people who they can't find the points, they're all over the place, they're incoherent, unprepared, no research, ignorant on key issues, no talking points, messaging all over the place, embarrassing. So no, I'm saying, sometimes we've got to look at, we want this space to be flourishing, exciting, energetic, vigorous. But if you're getting someone who, when we ask one question and they, take 2 minutes to, within 30 seconds, 45 seconds, you sharp and then, So I'm just saying, I'd like to really go back to in the past where people jumped at the chance to be interviewed. We'd call people at 6 in the morning and they'd be ready to be interviewed for the 7 a.m. news. Now it's, I'll have to get approval, and we really have to go back to, we really have to change this whole culture. And now they're telling journalists to debate on their behalf. You need to turn up and debate, not get us to ask them this question, ask this question, so. And then there's a tactic now that only a few people authorized to speak. It cuts out a big chunk of the candidates that need to be heard. So big time will call for, can we get this person, can we? No, and they send the same old people over and over again. I really look forward to the time with we used to hold debates. Chalembamba, Mick Badows, get your spokespeople who know how to speak and pass that message across, It's, we really need to make a change in this next election, starting from now, Okay, using of for Facebook and social media, good. Shaista said it, some parties are doing that. But now we notice that some of the parties are posting on their social media without engaging or sending it to the media. And then they expect us to go and look for it in their social media. And when we don't, they accuse us of not using it. You have to make an effort to reach us. The effort can be all on our side. So you've got to engage. Social media is good, but we are here for a reason, because we can bring the credibility, the cross-checking, and the responses to it. So I just want to end by saying that for me, the change and reform cannot just be legislated. It needs a change in our democratic culture and attitude, how we vigorously practice it, and we need to be more creative and let it flourish. Obviously, we have to cover a range of issues here from the media, GDP, some political party leaders don't know that, Auditor General, the debt, poverty, minimum wage, etc. Voter awareness campaigns, we can do better. We must do better because, and it needs the effort of all stakeholders. I've too often found people still turning up to the polling station not knowing what to do. That's a failure. And they're asking around, well, what? So we got to make a better effort. So rather than more legislation, I say we create more sound democratic structures and institutions. For instance, like the presidential debate in the US. It's not constitutionally mandated or in the electoral law, but it's seen as like an important part, interesting part of the election process. And we've got to build some of those for ourselves. In terms of electoral system, I'll just end. Yep. Everyone's talking about this system. In the end, sometimes talk to the people. And when we talk to the people, who do you want? And they said, we want to vote for someone we know. That's just the feedback I want to give. Sometimes let's just talk to the people. Thank you.
Thank you for that. I think one of the things that's coming out of research all over the world at the moment is the leadership is the critical issue, not institutional structure. Institutional structures provide some framework, but it's the leadership and the culture that actually determine what the outcome is. And the issue here in Fiji of penalties, it's even worse than Malaysia. And Malaysia is pretty draconian in the way in which it treats people. So I think a really important issue to raise for reform. Now, we have some time for questions. Can we put off people really hungry and need their morning tea, or have we got time for a couple of questions? Do we have time for questions? Yeah. Okay. I'm sure there are some political parties that might want to ask a couple of questions after that. Now, up here and over here.
Vinaka Wakalevo, Asala Temalan again. I know you're tired of listening to my questions, but I would like to take us back to the basic of electoral reform. It's about the people and about a balanced representation of power in Parliament. So while I agree with Dr. Shamim on the sexual respect that we need to have, but that's not the issue right now. For the last 4 years of election, there is a lack of representation of women. And I say that because our birth certificate, regardless of what you've said about the Constitution, the birth certificate still remains the same. There's a male and a female. That's the legal document that endorses the reason why we are calling for reserved seating for women. Because women are the ones that that have the divine capability to nurture children, and who are in a state of problem right now. They are the children. And if you see our parliament composition the last 4 years or even more, there has been less and less women, and yet we make more than 50% of the population. I say this with an urgent call that we need to do something. That's the main issue right now. And we've dealt with the ethnicity, and we've done well there. Now let's progress to how do we get women, more women in parliament. I cannot think of any other way but to do reserved seating, to change the culture quickly before it's too late and we become another America in little Fiji. While it's still manageable, let's take that as the priority. We also, and I will say this, between men and women, women will consider sexuality and the decision of it at that level more than men. And you've seen that, Dr. Shamim, at the level that you've experienced leadership. So that's what I would like to say, and I would also like to see that be part of the reform for all the women who cannot be here to voice their opinion.
Can we have the questions from this side and keep them to questions, please, rather than statements, and then we'll have the panel sort of respond.
Vinaka. I'm a retired civil servant. So just an interested member of the public. Interesting hearing what we've been hearing over the last, from yesterday till today. Yesterday, the executive director said that the commission that is going around, Electoral Commission, is going around, he said that their chair said that the attendance at the venues was very poor. A few minutes after that, Ms. Tivanga comes along and says, I think she was trying to be diplomatic. She said that, you know, they meet 2 rounds and they met market vendors. And my point is, and I think I raised this with Dr. Shamim while we were going out for lunch. I witnessed 4 coups in this country. Every time we have something like this or we have elections, there seems to be a coup happening. I may be wrong. This is my observation since 1987. And my concern is this: if there was no proper, if the people are not being reflected in the consultation that's going around, then why are we sitting here? Because the people matter. In my opinion, and this is I'm Itoke, I can tell you something today, and tomorrow I can change my mind, just like that. This is my observation of the Fijian psychic. People say we are the world, we should be the way the world should be. I say Fiji is not the way people think. We are different. So, and Satish, I think, Vijay, sorry, he made a very important observation yesterday. Where are the people who matter? Government, elections office. We need to hear them. And then we have this Supreme Court ruling pending. In the 5th question that Dr. Savim raised is the most important one of all those. We know that the court ruled that the 1997 Constitution is still valid or intact. It's set there in stone. So we don't know how it's going to play out. And we hear the commission saying that they have thought about 2 scenarios. 1, the status quo continues, or 2, whatever happens. How will they be able to able to see what's going to happen? Nobody's going to know what's going to happen, including the ruling by the sitting judges of the Supreme Court. So it's just an observation. I hope the panel can, I don't know, elaborate more on this, but those are just my concerns. Thank you.
Thank you. Let's take one more question, then we'll have the panel respond, please.
Satish Kumar from Fiji Labour Party. My concern, many a times, and rightfully, we focus on the process. It's important, very important, the legislation governing, or what we can say, the rule of the game. Equally important is the behavior of the voters. Do we need to be told who was the father of the coup culture? Who was the rapist of the democracy in this country? Are we recycling this type of politicians time and again? Does that decision depend on the system or the votes? It's the voters. We mandate people into that high organization. When they don't perform, many times we must be honest and blame ourselves. We made a wrong choice. Awareness of how to vote, whom to vote, what are the factors to look into. that culture of polarization, or because he's a Itokai candidate, I must support. He's a Kandia candidate, I must support, must go away. We must look into the merit, the ability to deliver at a national level as a paramount factor than anything else. Thank you.
Thank you. Can we have the panel answer? Oh, we've got one more question. Okay, one more question and then we'll have the panel respond. Could you please, again, keep this to a question and not a statement?
Good morning, everyone. My name is Manoa. I'm G Truth and Reconciliation Commission. Fantastic contributions from all of the panelists. What I was wanting to say really builds up from a little bit of what everyone has said. And this is just in the fact that, you know, the open list PR is the best system we have. It's not perfect, but it's the best thing that we have. And I'm just thinking, I'm sitting here, I'm thinking about representation, women, and, you know, with such a, better? Front? Okay. With such a system that we have, and seeing how it's being implemented, we have fewer women in parliament today, even less young people. And even in the past 3 elections, we've had capable women, capable young people who have been fielded, but they have not been elected. So maybe just a rhetorical point, something on the astral planes. With the current system and the current situation that we have, how confident are we that in the, say, next 10 years or 15 years, are we gonna see true change and true representation come as a result of us using the open list PRs? Thank you.
Thank you for asking a question. Okay, can we please have some responses from the panel, starting with Professor Shamin?
Okay, I'm not sure which question I'm answering, but maybe the lady over here, Ms. Malani. True, I agree with you that, you know, if you're going to be defining women in a particular way, then you can put that whatever reserved seats or whatever you want. But the problem is you can't, right? And just relying on the birth certificate, legally speaking, is not the answer to that, because the Scottish Supreme Court has already ruled on the different ways in which you can identify with different gender. And our constitution, which is the supreme law, says gender expression has to be protected, and there has to be prohibition from discrimination on the grounds of gender expression, gender sexual orientation, and gender identity. So I think you'll end up just trying to balance out, you know, all those issues. What we have proposed, which we couldn't really say here because of lack of time, in our electoral submission, this is the University of Fiji and Dialogue Fiji to the commissioners, was that there's our idea is to provide public funding for political parties. And the public funding should be based on their own ensuring that there's sufficient women, however defined, in the 40% of women in the party, and public funding is linked to that. So rather than putting it into the, you know, changing legislation for that effect, because once you do that, you'll be opening up to everybody else as well. There are many people who are minority groups, people living with disabilities, people who are from a particular remote island, the Kumbia, for example, or something like that. No, we want representation there. There's only 500 of us, but we want to have one person there, because who else is going to give our voice? So I think it's a really difficult area, because you're going to be negotiating this forever and never have elections while we're busy negotiating. So I think our response to that was that the political parties should be made responsible for having 40% women in their parties, and if they do, then public funding would actually be kicked in for them. So the responsibility is there rather than in Parliament itself, and doesn't involve any change of legislation. So that is our view on that one. And as far as, I'm very interested to know from the gentleman over there that he thinks every time there's either elections or electoral reform that there's a coup afterwards. We'd have to kind of do some analysis of that to see whether or not it's true, but I think that I will go back to what I said right at the beginning, and that is if we keep looking at ourselves as a conflict-ridden, a divided society, then we're always going to see problems when there may not be problems. And I think we really need to think about ourselves as being part of the solution and not part of the problem. And that's what I would advise, that let's look positively at the next one. We just have to make sure that all the systems are in place and that nobody's using the difficulties of the current constitution, because as far as I'm concerned, there's, like, for example, gender expression and gender identity. Those are positive things about the 2013 Constitution. And certainly when it comes to the protection of the LGBTQIA+, and I deliberately say the whole title because that's the spectrum there, then that's protected under the 2013 Constitution and none other. So I think we have to be really cautious about what constitutional change we want. Thank you.
Yeah, okay. So I'll probably respond to what Ratu Manwa from the Truth and Reconciliation Commission said. The thing is, I mean, the question of whether OLPR has led to some of the desired outcomes that we need in a society like Fiji, I think it has succeeded to an extent. If you look at the creation of a multi-party system within Parliament, you know, NFP has been the key beneficiary of the OLPR system, or the proportional system that we have adopted. You know, in previous elections, particularly in 2001, 2006, even though they were consistently polling around 7% of the total vote share, they were not getting any seats. Under OLPR, they have been winning seats. So it has sort of led to a multi-party legislature as opposed to, you know, two-party legislature that was commonplace under the previous system. As far as the inclusion of women is concerned, I think there's evidence from, you know, elsewhere that OLPR tends to, you know, assist in the election of women rather than single member districts under majoritarian or plurality systems. We haven't achieved that entirely. All right, or at least the progress that we've made has not been satisfactory, but we cannot be linking it to be a failure of the electoral system. It has got to do with the fact that not enough women are getting nominated as candidates, and that not enough people are voting for women candidates. And you know, regardless of which electoral system you're going to be adopting, you're not going to receive, to drastically increase the proportion of women in the legislature, unless you come out with controversial measures like reserve seats. Right? Again, having a reserve seat, for instance, you know, 10% of MPs to be women, that can in fact also lead to tokenistic representation of women in the legislature. You know? So the question is, how do you actually achieve a critical mass of women in the legislature? And that is around 35-40%. And I don't think anybody will accept it if you mandate, you know, 40% of seats to be reserved for women. So this is the kind of, you know, analysis that is also needed in as far as, you know, considering the various proposals that have been made is concerned. You know, I also realized later on that, you know, from my presentation it might have come out like I'm a staunch proponent of the status quo. I'm not. In fact, I ran out of time, but there were, you know, a couple of slides that I had, maybe you guys can put it up, where we have, you know, made a comprehensive list of the shortcomings of the Electoral Act, Political Parties Act, you know, the fact that the supervisor of elections has too much power under the Electoral Act. There's a lot of restrictions on the media, civil society, you know, there's partition, observation, accreditation. The minister responsible for election gets to nominate and approve observers. There's very harsh penalties, you know, up to 10 years jail for mere infractions. You know, there's a lot of issues, of course, you know, in the with the sanctions regime. And then there's also problems with the Political Parties Act. For instance, the powers of the registrar to unilaterally register a political party. There's also things like the $10,000 donation cap, which is static. You know, the ban on corporate donations, which is leading to the use of backdoor channels, the use of straw donors by corporate entities and so forth. So there's a whole list of issues that we also see, but these exist mostly at the legislation level. So a lot of these things can be remedied through legislative review rather than constitutional change, and they are not going to impact on the fundamentals of the electoral system at all, right? And I think most of us would now agree from the deliberations from yesterday that it will be very unwise to change the electoral system. In fact, it would contravene international norms if we change the electoral system 12 months before an election is due.
No, I think I'll just say be better prepared. Let's try harder. Don't give up.
Okay, I think we need to end the session here, Nilesh, is that correct? Yes, so we can all get some morning tea and prepare for the grind of the session after this. Thank you very much to the panelists, and thank you for the questions from the audience. Thank you.
Thank you very much, panel, for the thought-provoking and captivating perspectives. Yes, we have reached our scheduled break. We're a little bit over time there. So take the opportunity to relax, to network amongst yourselves, grab some afternoon tea and light refreshments. And we have about 10 minutes, just cutting it short by 5. So you can come back in time and we can continue the next session, which will be a technical presentation building on what we have discussed so far. And it will be in a workshop format, so it will be very interesting. We'll see you then. Thank you very much. Thank you, everyone. We'll just settle down now and move on to the next item on our agenda. And this is a technical presentation on electoral formula, district magnitude, and ballot structure. And we will have a presentation by Mr. Alan Wall, as well as input from Mr. Nilesh Lal of Dialogue Fiji. Alan, over to you.
Okay. Put that up. Good. This would normally be the session that would be after lunch in a workshop, so you can all go to sleep and not miss anything. But we're doing it now. I'm sorry, this is going to be full of mathematics. Does anyone here love mathematics? Oh, that's good. You might enjoy the session. Anyone hate mathematics? Maybe you should go back out to morning tea again. Have a little bit of a break, because there's a lot of mathematics a little bit later on in this. I'm going to have to go through this fairly quickly. We're talking about three things that are integral to the operation of electoral systems. And then after that, you've got a little exercise to do to exercise your brains, and people will be coming around and putting some sheets of paper on your tables, and I'll tell you what to do with them a little bit later. Okay, let's start going. We're talking about three critical elements of an electoral system, and I'm doing it back to front from the program because it seemed to fit a little bit better. What the ballot structure and design is, the electoral formula used to change the votes for voters into the representatives into Parliament, and a little bit about district magnitude and how that might have an impact in Fiji. First of all, looking at ballot structure and design. Now, there are two separate issues. Structure, how the voter choice or choices are expressed. Is it one choice? Is it multiple? Are those choices ranked? And how do they express them on the ballot paper? Second, what does the ballot paper look like? How do you design a piece of paper that allows voters to actually show those choices easily and understandably to them? Just want to go through the way in which this is typically done in a number of various electoral systems, and then look at some variations in OLPR, because the open list ballot paper in Fiji is very different from open list ballot papers in the rest of the world. Okay, first, easy, first past the post. You've got the candidates, you have a box, you mark one of those candidates. So the structure is just a single choice. The design is very, very simple. Second, block vote, also very simple. And this is an example rather than actual ballot paper, because Singapore is one of the few countries that has block vote and doesn't allow you to get copies of their ballot papers. So you basically have the parties listed in a group, you mark which group you want to vote for, and whichever of those groups wins a majority or a plurality of the votes, wins every seat in that electoral district. It's the most disproportional system known to anyone, and many people would regard it as a non-democratic system. Alternative vote. This is an example from Australia. Very, very complex system, both to design a ballot paper that's understandable and for voters to actually vote on this ballot paper. It's not uncommon to have this many candidates, stacks of independents. Here, people have to number 1 to 22, have to keep track of all their preferences from first through to their 22nd most high preference that they want. Complex for the voter, complex to design. There's very little else you can do with a ballot paper that runs pure AV than something like this. There are above and below the line versions of AV, but they tend not to be not to work the way in which alternative vote is meant to work. It takes away choice from the voter. So, complex system, complex for the voter to fill in the ballot paper. Next, single non-transferable vote. This is an Indonesian ballot paper for the upper house. Easy, you have multi-member districts, you just choose one person. Easy for the voter, easy to design the ballot. Now, this ballot paper has photos on. And recent research from Professor Renwick in the UK is showing that if you have you have a candidate photos on the ballot paper, you end up with significantly more trust in the election outcomes. which was a bit of a surprise to me, but this is what current research is showing. This again is easy to design. You just put the candidates on the ballot. The structure is easy. The voters just vote for one candidate, and the highest voted highest voted candidates are the ones that are elected. If you have 4 vacancies, the ones of these candidates that have 4 votes, have the highest 4 numbers of votes get elected. This is common in systems where parties are weak or where they want independents to contest the election. Now, closed list. This is 1994 ballot paper from South Africa, where you just have the parties listed and you have a photo of the leaders of the parties to make it easy for voters to actually recognise which party it is that they're voting for. Now, when you talk about big men and OLPR, this is an example of how big men or big people also have a huge influence in terms of how people vote in closed list PR elections as well. You can do it differently in closed list. This is one from Costa Rica. Now, while you only vote for the party here, the party has to list all of its candidates on the ballot paper, so you know who it is that you are voting for. This is not very common in closed list PR, but it is a ballot design that is used in a couple of countries. Single transferable vote, another PR system where you basically, like alternative vote, have to number preferentially each of the candidates. The candidates here in Malta are grouped by party, and you have to number your preferences from 1 through to however many candidates there are for your vote to be valid. Again, very complex for the voter, and a fairly simple ballot structure, but it's a complex way of getting the result and a complex way of a voter actually completing the ballot paper. Mixed member proportional. 2 styles of ballot structure are used. One is like this in Lesotho, where you have a single ballot paper which basically has the candidates for your district on it. You vote for that candidate, the single candidate you want, and those votes nationally are pooled for each party to get the proportional representation part of the election. So you have one vote that counts towards 2 separate elections. The other way is the German and the New Zealand method, where you have a double ballot paper. You vote for a political party for the proportional part of the election, and you then vote for a candidate for the single member district part of the election. Totally different ballot structure, totally different way of voting, but the same electoral system. The New Zealand and German way tends to create a lot of anomalies. It's generally now held to be much better to use the Lesotho way of doing it, because otherwise parties using the 2 votes, parties can manipulate the result by having straw parties or straw independents stand in the single member districts who are in fact supporters of major parties. They can use this to influence the proportions of the seats that they get. Can't do that with a single vote under MMP. Now, let's look at a variation in OLPR ballots. OLPR, like Fiji has, but OLPR is a concept. It's not really an electoral system. There are almost as many variants of open list PR as there are countries that use it. And there's a number of ways in which they vary. The most critical of which is who the person votes for and how many people they vote for. There are open list systems like Fiji where you vote for a single candidate, and that vote is pooled to the party. This makes it often, as we've seen in the criticisms of OLPR here, difficult to understand the proportionality of the system and why some candidates are elected and other candidates. Perfect adjustment. Thank you. There are other OLPR systems where you vote for the party and then may vote for a single candidate. There are other OLPR systems where you vote for the party and can vote for multiple candidates. Sometimes a limited number, sometimes for as many candidates as there are in the electoral district. There are other OLPR systems where you can vote for a candidate or you can vote against a candidate. So you can both put a tick mark against a candidate or multiple candidates and cross candidates off the list if you don't like them. And they're treated as negative votes. So OLPR is a concept, and while it says OLPR in the Fiji constitution, OLPR is understood in many, many different ways across the world and has different impacts as to the way in which it's implemented. Let's look at some of the ballot structures. This is Netherlands. Here you vote for a party up the top, and then you may vote for a candidate underneath. You don't have to. I have some issues with this sort of system because it's very difficult at the end to ensure election integrity in the candidate allocation. You know how many ballot papers you know how many votes for the party you should have. That will be equal to the number of ballot papers you have. But you don't know how many votes for candidates you should have. You know it should be equal to or less than the total votes for parties, but you don't know exactly how many it should be because it's optional to vote for a candidate, or in other systems, multiple candidates. Similar in Kosovo, but here it's much more difficult. You're electing 120 people from the one ballot paper. You vote for a party on the left, and then similar to in Fiji, you select 5 numbers which correspond to the 5 candidates you want to vote for on the right. And here again, you can vote for no candidates or anywhere between 1 and 5 candidates. So it becomes particularly difficult to reconcile the integrity of the candidate votes at the end of the election. Honduras. Here you only vote for a candidate, as you do in Fiji. But you can vote for up to as many candidates as there are standing. So here, there's what, 1, 2, 3, 4, you can vote for 8 candidates if you feel like, or you can only vote for 1 if you only like one person on the candidate list. But you see, they all have photos, and this is one of the advantages of having smaller electoral districts, that you can actually design a ballot paper where people makes it much, much more easier for voters to understand who it is they're voting for. You have a similar system in Ecuador, but the ballot paper design is different. Again, you vote for a candidate, and you can vote for as many candidates as there are on the list. But they've designed the ballot paper vertically rather than horizontally, as it is in Ecuador. It's similar in the Democratic Republic of Congo as Fiji, but here, similar in that the candidates are all randomised on the ballot paper, but you have a multi-page ballot paper with all the candidates and their details and their photos and their party printed on it, again with a huge electoral districts. Multi-page ballot papers are not easy for voters to handle or for election administrations to handle. Not generally a good idea. Then we come to Latvia, also OLPR. Now, in Latvia, they use not what we'd call an Australian ballot. Now, an Australian ballot is one where all the candidates from all the parties are listed on the single ballot paper. In Latvia, each party has its own ballot paper. So you select the ballot paper for the party you want from a pile, and then you mark the candidates from that party on that ballot paper, put it in the ballot box. It has some issues with ballot secrecy. Also in Latvia, as you can see from the instructions, you can vote against candidates as well as for candidates. You can cross the candidate's name off the list, and that counts as a negative vote against that candidate. This is Sweden, which is similar to Latvia. You can see here how the ballot papers are all sitting there at the polling station. And you select the ballot paper for the party you want and mark. In Sweden, you can vote optionally for one candidate, as well as you know which party you're voting for by which party's ballot is in the ballot box. And then you can vote for one of the candidates on the candidate list. Now, Sweden is a particularly strange place because in Sweden, up till recently, the parties had to print their own ballots. So if it was a small party and they didn't have much money, it was difficult for them to put ballot papers in all the polling stations. Not a very good idea. Estonia, again, you have a vote here for one candidate only. You don't vote for a party, just for a candidate, but you don't have candidate names or numbers on the ballot paper. You select the number of the candidate you want to vote for and write it on the ballot paper. Just starting to get confusing. And this is all the one electoral system. Look at the different ways in which it's being implemented. Different ballot structures, different ways of voting. Sri Lanka, again, here you vote for a party and you can vote for up to 3 candidates, but the party's up the top, and then you have the candidate numbers down the bottom, and you mark them. So you vote for the party you want up the top, then you tick however many candidate boxes you want to vote for, up to 3. Indonesia. Here you can vote either for the party and not vote for a candidate, or vote for one candidate. Panama. I guess similarly, you vote for the party and up to as many candidates as there are on the list. So in here you've got 4 candidates, you've got a 4-member electoral district, you can vote for up to 4 candidates. Cyprus. Cyprus again has a French ballot. So each of these are separate ballot papers. They're just sitting here together. So you pick up the party you want to vote for, and here it makes it even more difficult for the voter because you don't vote for a specified number of candidates. You can vote for up to 25% of them. So the voter's sitting there working, hang on, what's 25% of 11? Now, how do I vote for the right number of candidates on this ballot paper? And Denmark. I had to split this ballot paper up into several sections because it was a bit too long to fit on the slide. So here again, you vote either for a party or you can vote for one candidate. Now, all these are the one electoral system. All of these ballot papers have various positive and negative features. So you can see how within what the OLPR system that Fiji has, if there were not the restriction on having to vote for one candidate, you could have very, very many different systems within OLPR. And those that actually get people to vote for a party as well as a candidate tend to reinforce party identity and reinforce the fact it's a PR election more than those variants that get you to vote only for a candidate. The downside of that is it's harder to ensure integrity of the election if you do it that way, because it's really difficult to reconcile your ballot papers afterwards with each of the candidates' votes. In fact, it's impossible. I had situations in Kosovo where the party would sit there and look at the total votes for the party, calculate how many fewer votes there were in total for candidates, and then subtly adjust the result sheets. So 10 would become 110 for a particular candidate, or sort of 5 would become 55. And they weren't doing that to adjust how many seats their party got. They were doing that to try and influence which of their candidates they actually wanted to get into government. So they had to put in measures to stop that, a whole electronic system to stop this from happening. Okay, so that's ballot structure. Gets confusing, doesn't it? Now, let's get into the mathematics with electoral formula. This is how you look at the mathematics of how votes determine how many seats each party wins. Now, in some systems, it's really simple. For first past the post, candidate with the highest number of votes. 2-round system, first 2 candidates from the first round, if no one gets a majority, go into a second round, and then the candidate with a majority of the votes wins. Very easy to calculate. Block vote, if there's say 10 members to be elected, the candidates with the 10 highest votes get elected, and you have multiple votes. Party block vote, similarly for a party. Single non-transferable vote, you have 1 vote, and if you have 5 seats to fill, the candidates with the 5 highest numbers of votes. All these are really, really simple, but they're all highly disproportional. And they all result in large numbers of wasted votes and large sectors of the community not necessarily being represented in a parliament. Alternative vote, similar but more complex. I'm not going to run through it all because you guys have had to put up with alternative vote in the past, so you should have some idea about how it is it works. But you basically, if no one gets a majority of first preference votes, you keep on distributing people second and third and lower preferences until a pile of papers for one candidate has got a majority of the votes in the election, 50% plus one of the votes. Then we come to PR, and then it becomes a lot more complex. Complex going back to the 19th century when there were competing views of how is the best way to get equality between the number of votes used to elect one candidate. How equal should it be? And one of the things with the formulae in PR is that they are also impacted by if you have a representation threshold. Because if you have no representation threshold, all the votes for all the parties that compete are put into the mix for the formula. If you have a representation threshold, only the votes of the parties that meet that threshold are put into the mix for the formula to calculate how many seats are being won. Now we've got two different styles, basically, of mathematical formula. Often people refer to them as highest average methods and largest remainder methods. This is where people can go to sleep if you feel like going to sleep for a while. Yeah, I'm not sure that you're going to, how much you're going to retain of all this. Largest remainder methods are simpler to understand. You can actually see very easily on a single sheet or a small sheet of paper how it is the seats are being allocated. And there are some systems that use a combination of both. They might allocate the first seat from each party by highest average, and then the rest of them by largest remainder, which gets really complicated. And what happens with these is that some of the formulas may give different election results. Now, there are statements in some literature that says, Dont favours big parties, St Lage favours small parties. That's not correct. They may favour one or other size parties, not necessarily do favour. It depends on vote distributions. Got it. Okay, let's look at highest average methods. Now, the way you do this is you take each party's votes and you divide them by a series of divisors. And there's normally as many divisors as there are seats to be allocated. And then in practice, the results of those divisions, which are called quotients, you rank highest to lowest. And if you say got 10 seats to fill, the 10 highest of these quotients correspond to the number of seats that party gets, and you allocate to the parties in that way. Now, you can see here there's lots of variations, and I haven't given all the variations of DONT because there's multiple ones of them as well. So the basic DONT you divide by 1, 2, 3, 4, 5, 6, 7. Just go up a number each time. Basic Imperiale, which was the Italian method, you do 1, 1.5, 2, 2.5, 3, 3.5, etc. St Lage, which is probably the one that more countries are using now than other, the basic version you do 1, 3, 5, 7, 9, 11, 13. So you go up by 2 with your divisors. There are a number of modifications to St Lage that I put here. In Sweden, it's 1.2357. Denmark, 1.4357. And the reason this is because there's a perception that St Lage favours smaller parties. If you slightly increase the first divisor, you slightly reduce the chance of really small parties of being allocated a single seat, which is why they have those crazy 1.23 and 1.43. Then you get to early versions. St Lage basically emanated largely in Scandinavia, was used largely for the first time in Scandinavia. Early versions in Scandinavia had crazy things like the divisors were 1, then 15/7, then 25/7, then 35/7, 45/7. And in Denmark, currently, the party primaries are run on the St Lage version that goes 1, 4, 7, 10, 14, 17, 20. So it goes up by steps of 3 rather than the usual 2. Okay, confusing? Let's get to largest remainder systems. Because again, there are a number of ways, but not as many, that you can basically allocate seats under largest remainder. And the basic way it goes is you divide each party votes by what you call a quota, which is used as the basis for allocating seats. And initially, you allocate party seats on the basis of how many whole quotas they have. And if this doesn't result in all the seats being allocated, you then look at the remainders and you allocate any remaining seats in order of how high these remainders are. So if I've got, say, a party who has 2.5 quotas and a party that has 1.3 quotas, and I've got 4 seats to allocate, the party with 2.5 quotas gets 2 quotas, 2 seats. The party with 1.3 gets 1 seat. That's 3 seats. The additional seat goes to the party with 0.5 of a quota left, because it's the highest remainder left. Understand? Okay. Now, there are a number of different quota calculations, all devised by various mathematicians who probably didn't have the ease of voters in mind when they were devising the quotas. Basic one is the Hare quota, and it's the simplest. You take the votes that are there in total and you divide by the number of seats to be filled. Now this creates quite a high quota. It normally means there are fewer full quotas won by parties, and it may favour smaller parties because there's more remainders. Droop changes it a little bit. They have votes over the number of seats to be filled plus 1, and then they add 1 to that total. That's probably the most common largest remainder quota used. Hagenbach-Bischoff, you don't add the 1 at the end. You just have votes over seats to be filled plus 1. So if I've got 100,000 votes, I have 10 seats to be filled. I divide 100,000 by 11, and that gets me my quota. If it was Droop, I'd do 100,000 divided by 11, and then add 1 on to that calculation. Imperiale is very rarely used. It's votes divided by seats to be filled plus 2. So if it were 100 seats, 10 seats, 100,000 votes, you would get 100,000 votes divided by 12. Now, Imperiale has one huge problem, which is why people don't use it. And that is, in certain vote distributions, you can end up having more full quotas than you actually have seats to fill, which is a little bit problematic. You've elected more people than you need to elect. So you then have to go through some sort of countback process, and it varies in different Imperiale systems as to which of those parties loses one of their quotas. That's the reason very, very few countries use Imperiale. And when we're talking about votes, we're talking about valid votes less any votes for parties that don't meet the threshold. You can't include them in these calculations. Understand? Okay, let's see how it works out in practice. What I've done is look at the 2022 Fiji election results and redone the calculations based on different forms of quotients. Okay, I'd become unplugged. I was just about to sink to the floor. I've lost electricity. Okay, what this will show, I think, to you is that the way in which you actually do the seat allocation is generally not as important as the level of the threshold. That you can have multiple ways, be it DONT or various Sant Lage ways or various largest remainder ways of allocating the seats, and you'll come up with the same or similar results. But as soon as you start changing, or when you change the threshold, you can come up with different results and very much higher representation of small parties. Now, this will again depend on the distribution of votes between parties, but it's certainly true of Fiji and the way votes have been distributed here. So we look at things on a 5% quota, we see that really, no matter which of the systems you use, you're getting very, very much the same result, except for when you use Imperiale, both as a highest average system and as a largest remainder system. And I have to tell you that the largest remainder Imperiale system down there, I had to adjust because it came up with 56 seats for a 55-member parliament. Not good. Then we dropped the quota to 3%. And we find it's basically the same result. making no difference whatsoever because of all the small parties have been excluded from the distribution. So the changes in party representation are going to depend on how many parties are excluded and included in the count. If you're getting rid of all the small parties using a representation threshold, there's no way that using a formula that may assist small parties is going to make any difference whatsoever. It's the representation threshold that is the critical issue. So 3 and 5%, basically the same result. Dropping it to 3% on the 2022 election data makes no difference. Now, that doesn't mean that you couldn't have a different distribution of votes. It does mean, I think, that you have even more parties contesting in the next election. It'll reinforce this process where 5 and 3% quota is not going to make any difference. And the way in which you allocate the seats is not going to make any difference because you have 17 parties, your vote will be split amongst even more small parties. Let's drop it to 1%. Now we're starting to see a change. Not because the votes have changed, but because one more small party has managed, or two more, have managed to get into the actual vote count. If we look at this one, your quota is still 14,000, threshold, sorry, up the top is still 14,100 votes. And you only got 4 parties that meet that. If I drop the quota to, threshold to 1%, I suddenly have 3 more parties that are included in the count, included in the seat allocation. This does make a difference. And you can see here that there is a difference between Dont and St Lagre. One additional party under St Lagre is getting a seat that wouldn't get it under Dont. So here that effect of Dont favouring larger parties is coming into play. It's because the threshold's basically gone. Let's drop it down to 0%. Okay, no threshold. And now you have, again, a little bit more under Dont, one more party coming in, but then it reinforces the allocations to smaller parties under the various forms of St Lagre, and even under Imperiale. Interesting? Very interesting. But remember, this depends on the mathematics of the vote distributions. But the more parties you have competing, the more the threshold is likely to have an impact on who actually ends up in seats, with seats. And the whole idea of having a threshold in many electoral engineers' minds is to consolidate parties. Say, well, okay, parties will be have self-interest in heart and they won't form a new party if they don't think they're going to win the seat because they're not going to get over 5% of the vote. That ignores the self-delusional aspect of people forming a party, because everyone thinks they're going to win seats, no matter what their prospects. So you don't just consider the formula, you consider the threshold. One thing that some party systems do is allow for pre-election coalitions, which aren't allowed in this country. Timor, for example, allows them. That means if a party congresses decide we want to ally with another party, the two parties keep their separate identity. They don't merge, but they can lodge a joint list for the election under a joint banner. And that helps smaller parties actually get over any threshold and win seats in Parliament. So that's one way people have approached. Let's have a threshold, but let's make sure that small parties have some actual chance of winning a seat, because they can amalgamate with other small parties just for the purpose of this election, form a pre-election coalition. And there's nothing that says they have to keep that coalition after the election. Once they get into Parliament, they can split again, which has been a problem for stability in Timor-Leste, because large coalitions have split and governments have changed, or large pre-election coalitions have split once they've got into power. So like everything electoral, there's upsides and downsides of taking that particular stance. Okay, let's say a little bit about district magnitude. Now, I'm not going to say a lot, and I'm going to get you to do an exercise on it. Have people got, yeah, they've got their sheets. Good. Now, this is about the number of representatives elected from an electoral district and how you determine this. Okay, there's two basic divisions that we've been talking about for over a day. Single member districts, you elect one representative. Multi-member districts, you have more than one representative. You can have multi-member districts under majority plurality systems, but they're not very good. And you generally have them under proportional electoral systems. You can't have single member districts in a proportional system, though there are some proportional systems in Africa that have some districts that do only elect one member. Now, whether you have single or multi-member districts, the important principle is that you have one person with one vote, and as far as possible, that vote is of equal value across the country. I said as far as possible. Except where a country is a single electoral district, it's impossible to have all votes with an equal electoral value. So there is a standard for this. Once you have multiple districts in a country, the standard is, as usual, from the Venice Commission. And it basically says that excluding some exceptional circumstances, and some of those may be to do with remote areas, the voter to representative ratio in each electoral district should not deviate by more than plus or minus 10% from the overall voter to representative ratio. And this applies to all elections, not just national elections, this standard. So if I've got 100,000 voters nationally, and I've got 10 seats nationally, I've got 10,000 voters, 10,000 voters, but 10 representatives, I've got 10,000 voters per representative. Now, in any electoral district, the voter to representative ratio should be between 9,000 and 11,000. Shouldn't deviate from outside that. So it's not exactly equal, but it is within a very compressed band range. That's the standard for it when you're doing multiple electoral districts. And you have some countries that go well beyond that standard. My own country has this very complex formula where the midpoint between elections, well, they try to draw electoral districts so the midpoint between elections, as far as possible, the number of voters, the number of population in each electoral district is equal. But they can start off with up to 5% variation. Okay. One of the things about multi-member districts is that you don't have to draw specific electoral boundaries, which takes a huge burden administratively and also means that you can't warp things ethically by having boundaries drawn by people that have political interests in their head rather than sort of equality of votes in head. You can relatively easily maintain one person, one vote, one value by using existing administrative districts and then adjusting the number of members, representatives elected from each district according to its population. You don't need to do specific electoral boundaries. It makes it less easy to have gerrymandering, less easy to have, particularly to have malapportionment. As we've talked before, it may be less easy to maintain voter to representative contact. John Curtis's research early 20th century, basically said that, I think the conclusion was more that in multi-member districts there is no less satisfaction from democracy than there is in single-member districts. People are just as happy with their democratic representation rather than with their necessarily direct contact with their representatives. That was the major conclusion. And it's probably a more important conclusion than saying they have contact. Their satisfaction with the level of democracy is the critical thing. Now, if you have proportional systems, the fewer the number of representatives you have in an electoral district, the less proportional the system is. Now, some countries, as I noted yesterday, get over this by having a second level of elections, distributing some seats at a national level to try and make up for the lack of, or lesser proportionality at the district level. The other important thing to note is that if you have multiple member districts, you still have a threshold, whether it's legal or not. You often don't need a legal threshold if you have multi-member districts. If you have 24 representatives elected, generally you will need around 3% of the vote to have a chance of having a member of your party list elected. If you have 14 representatives, generally, and these aren't hard and fast rules by any means, but they're approximations. 14 representatives, you'll need around 5% of the vote to make sure you get someone on your list elected. If there's only 9 representatives in the district, you'll probably need around 7.5% of the vote share for your party to ensure you have one person from your list elected. So there's no legal threshold, but there's this natural threshold just from the mathematics of how you split the votes up. Which is one reason why so many PR systems don't have legal thresholds, because they have multi-member districts. They don't need a legal threshold. Is that clear? Yeah, this is something a lot of people don't tend to understand or recognise, but it's an important factor in when people design the system as to what they want and how they want it to work. Now, multi-member districts would work a lot better for voter choice and ballot paper design in this country, but they would have a threshold, an inherent threshold there. Now, single-member districts, on the other hand, can make voters feel they have a local representative. So if you're doing your district magnitude of 1, you have someone that you can perhaps relate to. You mightn't talk to them, but you can relate to them. The real problem that is that you have to maintain this one person, one vote, one value. And that can be really difficult. Firstly, the nature and independence of the body that determines the electoral district boundaries. Is it influenced? The United States is the great example of that. While in the United States they don't allow malapportionment, the district sizes, populations have to be the same. They can do what they like to manipulate where the boundaries are to be able to get that equal population, which creates huge problems. The other issue is timing. Now, they haven't done a review of boundaries in the UK for, I think, 25 years, which means that the districts there are hugely malapportioned. Not through intent, just through people not bothering to do anything about it. Malaysia, it is through intent. The largest urban district in Malaysia has about 240,000 voters. The smallest rural district has 30. They each elect one representative. And that's quite intentional because the ruling Malay-dominated parties are scared of Chinese influence in the cities. So this is your problem with single-member districts. How do you keep them fair? Not only how do you keep the result fair, but how do you keep, in terms of proportionality of result, but how do you keep the districts fair? What mechanisms have you got in place to ensure that? And particularly where there's a danger of state capture of whoever draws the boundaries, this is a real problem. Okay, I just did a couple of exercises showing how you could possibly divide things in Fiji if you wanted to. This is not any recommendation, it's just an exercise to see what would it look like if you did it, based on 2017 census data. You could divide it by the administrative districts, and you'd have 4 seats. I made the assumption that you would want to have a minimum of 3 seats in the Eastern District. Having anything less would be unfair. And you come up with this distribution of 21 in the West, 8 in the North, 23 Central, 3 in Eastern. And this is similar to the 2012 sort of plan using closed list PR. When I look at the plus or minus 10%, of course the East, because we've boosted their representation to a minimum level, doesn't meet the plus or minus 10% criterion. The other districts do. They're still pretty large districts, 21 and 23 is a pretty large number of members to have elected. So I then looked at, can we combine, and this has got nothing to do with practicality, this is just to do with numbers. It doesn't take into account cultural affiliation or divisions or natural phenomena, etc., all those things you use when you do districting. If we combined the provinces in different ways, what could we come up with? Of things that were within not necessarily the same populations, but keeping the numbers of representatives down to a reasonable level. And I could come up with 7 districts. As you see, I've said this is just pure mathematics. It's got nothing to do with practicality. Amalgamated some adjacent provinces that cross administrative district boundaries. And you can come up with 7 districts that range of between 15 and 7 seats, apart from, again, the Eastern District, which is still at 3. All of these districts meet the plus or minus 10% criteria, apart from the East. And these are all done on a 55-member House, which it may not be for the next election, depending on populations. So I looked at it. What do we have? 59 members. Using the same amalgamations of provinces. A little bit more difficult to keep the plus or minus 10% rule. We've got another district that doesn't quite meet it. And then I looked at it also in terms of if we had a 61 member House. And again, all but the Eastern District can be, you can get within that plus or minus 10%. Now, I stress, these are not recommendations of things you ought to do, but these are the sort of mathematics people play around with when they're trying to work out whether you can have multiple districts and how they would work. So it may not be a practical solution, but it is a mathematical solution. Mathematics and practice doesn't necessarily go together. Okay, I'm going to shut up and I'm going to get you to do some work. You have some sheets on your tables. Now, I want you to work as a group on this because you'll need to fill in more than one sheet. Right? Your sheet looks like this. What we have, so please work as a group and come up with different solutions. Don't just come up with one solution each. We have 9 wards here. And in these wards, they're equal in votes. You have votes for the red party and votes for the blue party. I apologise for the print. It was meant to look like that. It somehow came out with dark backgrounds, which makes it a bit more difficult to look at. So what I want you to do is create 3 single-member districts. You create the 3 single-member districts by amalgamating those 9 wards into groups of 3 wards each, which have to be contiguous. Right? They have to. You can't have one. You can't amalgamate that one and that one and that one. Doesn't work. Right? The ones you amalgamate have to be next to each other, but you can do it in different ways. So, I want you to draw constituency boundaries for these 3 constituencies and see if you can influence who wins the election by how you draw the boundaries. That's why I want you to do it as a group and come up, see how many solutions you can come up with to forming 3 constituencies. How many different election results can you get from 3 constituencies? Okay, is that clear? People understand what they have to do? So use your pen to create but do it as a group and see as a group how many different answers you can come up with. We've got, how much time have we got? 5 minutes? Yes. Yeah, you've got 5 minutes. Then I'll show you what some possible results are. Yep. Yes, from each group of 3 wards, only 1 person's elected. Yeah, so you're forming 3 constituencies from these wards. This is normally how you build up a constituency, through census blocks or wards or other ways. If you have single-member districts, this is the way you do it. Votes. This is votes. So try and do it, yeah. Do it together and then mark your answers on a... Okay, are we understanding here? So try and do it together so you can, yeah, try and use your pen to outline how you're going to how you're going to amalgamate these things and see how many different answers you can come up with. So we can do any way you can combine them. Yeah, see how many results you can find. Yeah. We okay here? Each containing 3 wards. So you put them together and you add the votes up from each of the 3 wards and see what your who wins in each ward, red or blue party. No, well, what you do is you amalgamate the wards and then you add up the numbers within them to see how many overall votes each party gets within the district. So this is how you'd normally do a constituency. You would build it up from a census block or from a ward structure, and you'd amalgamate them together to form a constituency. And then put the...
Look at the numbers to see which gives you the higher number.
Or see who wins in each...
Put someone's name here?
No, just the number of votes. Party red, party blue. Which party? Okay, we're pushed for time, so we've got 1 more minute. Guys, let's see what you can finalise. I've got it down here. Yeah, I've got the one. You'll need to put it, put it up there, yeah. Yeah, and then when I give the solutions, you'll need to do it as well. We've got the solutions up here. Okay. We haven't really got time for you all to come up and explain what you've done, so I'm just going to show you some of the possible results that you can get following these rules. Right? And normally you would have contiguous areas in the district. You'd be using building blocks like wards or like census districts to make up your single member districts. So let's see what we can do. If we put the wards together like this, the red party wins all the seats. Blue party wins nothing. If I put them together like that, the red party wins all the seats. The blue party wins nothing. Again, there's 3 contiguous wards together to make each of the constituencies. But I get a different election result if I put them together vertically. Blue party wins 2 seats and the red party wins 1 seat. Haven't changed the votes. All I've done is change the constituent parts of the constituency. Put different wards, contiguous wards together to form the constituency. I put them together this way. Red party wins 2 seats, blue party wins 1 seat. So what's the fair result for the election? Right? What? What's fair? What should the election result be? And this is why single member districts can be problematic, because the way you draw the boundaries can determine who wins the election. Yeah.
Sorry, this is the question that we were discussing when you were looking at that size.
Yeah.
In terms of determining all of that, now that the red party has 2 seats, blue party has 1 seat, do we also factor in the number of votes that the red party got, as well as the blue party? Because I think that's what we discussed. This would be...
You've got the number of votes here.
Right.
These are votes, not voters.
Yeah, in total though.
Yeah.
So in total, I think red party had 740, right?
Yeah.
And blue. So that's why with the other example where blue party gets 2 seats,
Yeah.
I just think that's unfair given that blue got lesser votes than red.
But that's a feature of single
Yeah.
member districts. You can draw it that
Yeah.
way. And is it fair that the red party wins all the seats, as you can do under some configurations? You don't have this same issue with multi-member districts. It's much, much harder to be able to skew the representation, particularly if you use administrative boundaries rather than draw specific electoral boundaries. But it's interesting. I mean, Did anyone come up with any other results? Anyone come up with blue winning 3 seats and red winning 0? Because I don't think you can do it from these numbers. The only thing you can't get. But you can see how you can influence election results, not by the voter, but by whoever draws the boundaries. Look, thank you very much for your attention. It's been mathematical, arcane, abstruse, but these are all important things to remember when you're trying to design an electoral system that fits the needs of your society. How is the representation decided, and how many representatives do you have? Now, are there any questions overall before I stop? Yeah.
What is the effect of trying to bring the members of parliament together when you throw in a constituency office, where regardless of who you vote for, the winner from the district represents the whole constituency in a constituency office established by government, let's say?
I'm sorry, I'm not quite understanding.
A constituency office for its constituency
Yeah.
that looks after all the members, regardless of political party.
Okay, what a number of people do, and this is what, and it varies in effectiveness because it's not legally necessarily binding. In my country, for example, the Senate is elected by proportional representation. We have 12 senators for a state, right? And some states have populations of 6 or 7 million. And what they do is each senator has an office in a various part of the state that they use to deal with the local people. So you can do it that way. You can mandate having an office in various villages or district areas to which people have to be available a certain number of times a year or a month or whatever. So it is possible to do that. It's just not as formal as it is under single member districts. But as you see, single member districts have a lot of downsides as well, which you have to consider. The other issue, of course, is that, and I think Nilesh was going to talk about this but didn't, why are national representatives dealing with local issues? And this is a problem where you don't have proper elected local government through a country. There's these expectations on your national members that they deal with everyone's local issues. That is normally not the case because you have elected local governments that deal with these that are really close to the people. So that doesn't help. Not having elected local governments doesn't help in terms of local representation, in terms of local contact with elected representatives. And it's putting in some ways an unfair burden on the national representatives to expect that they do this. And maybe Fiji will have elected local government for some of the country at some time. Any other questions? Great, I'm glad you all understood that fully. That's great. Sorry to have to go into the mathematics, but thank you very much for your attention.
Thank you very much, Alan, for that eye-opening session on how we can, for want of a better word, scam the system. All right, we'll move on to the next session, and that is an extension of what we were doing yesterday afternoon. And this is a breakout session, and we will be reviewing 2 further acts. We did Electoral Act 2014 yesterday, and today we will be doing the Electoral Registration of Voters Act 2012, as well as review of the Political Parties Registration, Conduct, Funding and Disclosures Act 2013. So just to move things along a bit, this is how we'll do this. We'll have, there are 10 groups, 10 tables. We'll divide it up. 5 groups will do the Electoral Registration of Voters Act, and 5 groups will do the Political Parties Registration Act. Okay, so I have my team, some of the team members from Dialogue Fiji will be giving 2 pages of each of the acts on the tables. Okay. All right, brilliant. So that's what we will do. Out of the groups, we will be doing 5 of them will be doing the political parties, and the Voters Registration Act is a fairly simple, small act, and we'll just get 2 groups to be doing that and then presenting their findings later on. All right, so we'll just distribute that. Just give us 2 tables with half each. Take 1 for you. Yeah, this one for 5 people. You choose. We should ask. Which one is it? I should not go into the. अर्चना क्या भेजा रहा Oh, that one. हाँ वही लगी. ना इला तो इसमें से हुए अभी बट हमें सेट करेक्ट पड़ी बिकॉज़ हम कभी करते Okay, everyone, if you'll have a look at the screen, it gives you a little bit of context and a little bit of guidance under what you're supposed to do. So just review the sections of the legislation assigned to your group. You list the key strengths of the provisions, any shortcomings, any critiques you have of that, and you can propose recommendations. It's exactly what we did yesterday. And then, yeah. Anything you'd like to talk about regarding cooperative practices, etc. Now, another key thing there is you've got to provide some rationale or reference to what you propose or what you are critiquing. So this is a bit of an example. Here's the template you could use. Yeah. This is the template you could use. Strengths, shortcoming, weaknesses, recommendations with some evidence-based rationale around that. Okay, and this is the exact same template or process we will be using for presenting yesterday's electoral act review as well as these two that you're doing today. Thank you. Just a reminder, please, follow this exact template to do the presentations because your feedback will be coming along those lines. So we've provided butcher papers. Just drop a simple template along those lines. उल्टा ही बोला कर दो. Thank you, everybody. I hope we are concluding now. We are breaking for lunch. You have evaluation forms with you. If you'd like to hand them over to our team, any one of our team at any point in time from here till the afternoon, you are most welcome to. You've been given lunch tokens and you are okay to proceed to the lunch venue now. Thank you. you very much, everyone, for coming back from lunch. Very eagerly waiting for our session, evaluation of our presentations, or presentations and evaluation on that. Are we ready for this? Aye, lunch should make you more energetic. It's more like a denouement. All right, so we'll ask our evaluators today. Mr. Alan Wall. Alan, if you could come here, so you could do feedback from the podium. Yes. You'll be, whatever they say will be projected onto the large screen, Alan. Yeah. So this feedback session will be, the feedback will be presented by both Professor John Frankel as well as Alan Wall, and of course Mr. Nilesh Nal will be giving his input as well.
John?
Electoral Act first. We will start with yesterday's presentation, the group work we did yesterday, because there is the main piece of legislation, which is the Electoral Act 2014. So we'd like to start with group 1. Or any group that is ready to go ahead with the Electoral Act. Yesterday's presentation. Oh, brilliant.
Evaluate their proposal.
Group 3, thank you for volunteering.
Well, that's easy to evaluate. Nothing. I like that.
All right. Validation, okay. Validation.
Put it up on the board.
Okay, thank you. Our team would like to first of all introduce ourselves, and so we call, what's the name of our group again? We are the standalone party. There are several women with only one gentleman, and he's our president. And at the moment, he's still impressed with us, although he's holding back a lot of words that he wants to really say to us. Thank you.
Okay, on yesterday's exercise, we were dealing with polling and voting. We decided to look at section 863, subsection 12 on the votes tally. Well, the strength to us is that the votes will tally on that subsection 12, but then the weakness of it is that it doesn't give a voter a chance to correct their mistakes. And that's what happens, when you actually vote and you make a mistake. They don't allow you to sort of, give you another ballot paper where you can vote again. We think that it's a bit too strict, that if they can come up with another system where we can be allowed to vote again if you make a mistake. Section 63 under postal voting, which is covered for overseas living any serious illness or pre-trial, religious beliefs, work commitments and that. Sudden changes to that, they don't allow for that either. For example, I was in India for the last elections, and I had asked for postal ballots to be sent to India, which they did. All of a sudden, there was a change in the medical schedule, and I had to come back to Fiji. When I went to my polling station here in Fiji, they did not allow me to vote, even though I hadn't voted in India. So they don't account for that. On section 40 with disability, it's okay that the disabled are being catered to, but we feel that the person accompanying the disabled person can still influence the vote of the person who's disabled. So those are just the 3 points that we picked up yesterday. And we'll move into the exercise for today, and Agatha's going to discuss our points on that.
Okay. Any questions?
Yeah, if you have any questions, my team is here on standby since I've done the presentation. Yes.
Supervisor, did you?
Yes, I
And
did, yeah.
they still refuse.
Yes,
you
they
to
made
cast
calls, whoever they called above them, they didn't allow me to vote. Yeah.
Okay, if I can just respond to that. There's a very good rationale for not allowing people to vote in multiple ways. There's a need to reconcile the ballot. So if your ballot, the ballot that has been assigned to you, has been mailed out, you cannot get a second ballot. And they're keeping very close control on the number of ballots that are dispatched to each polling station. Right? And all of this needs to be reconciled, which is precisely why you get assigned a particular polling station, right, at a polling venue. Polling venue is, for instance, the school that you're going to vote. That is polling venue. A polling station might have multiple polling stations. So, and then you can only vote at the polling station that you've been assigned to. That is the only place where your name would be on the voter roll. Right? And that is to help with reconciliation.
Yeah, so on the voter roll, when I went to my polling station, my name was on the roll. But they were still not allowed, they didn't allow me. If I hadn't told them that I had got a postal ballot, they wouldn't have known.
And in relation to the other point that you've raised, that you are not afforded another ballot paper if you spoil the first one. That is not so. Right? You'd be given another ballot paper. Of course, you can't afford to be spoiling 10, otherwise you'd be upsetting, the whole thing, right? Because they cannot be allocating 10 papers to you to spoil, right? But you'd be given a second copy if you make a mistake. Not a copy, I mean a second ballot paper if you make a mistake with the first one.
Exactly what the executive director is saying happened to me. I mistakenly crossed the wrong one, and I asked the people at the venue if I could have another ballot paper. So that, but I thought in the legislation it says otherwise, but no way. You can be given. Where's the legislation? General Secretary, where's the? I'm trying to bring these ladies up to scratch. They still slack a bit. How can we form a party with this kind of women? Just stand alone. But we will get back to you, sir. I thought it doesn't apply, but executive director has straightened the record. I thought it was she did the wrong thing by giving me another copy. But he's saying that it was okay. It's under the legislation. I thought it was being illegal that I was offered another voting paper. So I voted again. And that time I got the right number.
Okay, so let's look at what section 83 subsection 12 says. It says that a voter whose ballot paper has been invalidated under subsection 11 is not entitled to receive another ballot paper. Now let's see what subsection 11 says. While in the place where pre-poll voting is being conducted, a voter is not permitted to reveal or announce the content of his or her ballot paper, and any voter who does so must have his or her ballot paper confiscated and invalidated by the election official in charge, provided it has not been inserted into the ballot box. So it is a misdemeanor for you to go and announce who you voted for. The secrecy of the ballot is sacred in elections. And if you do these things, then you wouldn't be afforded another ballot paper. Okay. In all other instances, if you make an honest mistake, then you'd be given a ballot paper, a second ballot paper.
Can I make a couple of comments on the third thing with disability? Yes, it is an issue that people assisting people with disability to vote could possibly influence them. However, it's generally regarded that that is better than not allowing these people to vote at all. However, the trend at the moment is to make sure that people with disability, as far as possible, can independently vote. And that means doing things like special voting compartments for people who can't reach normal voting compartments. It means having ballot paper templates or large print format ballot papers available for people with low or no vision. So the best thing to do is to make sure they can vote independently. The second best thing to do is to make sure they can at least vote and accept some risk. But it's accepted that if people are assisted to vote, there may well be some risk. And the fewer people that know how they are voting, the better.
Thank you very much, Group 6. Can we have the next group who's ready to come up? Group number 4, thank you very much. We are presenting on the same act, not the today's one, yesterday's one, Electoral Act 2014. We'll come back to today's one later.
Hello everyone, I'm part of group 4. Okay, so we very briefly looked at the counting process, and none of us were experts in this area, though we did have some issues that we felt needed to be brought to attention. We won't go into the technicalities of the counting at the main National Count Center. We'll more focus at the polling stations. So there were some small things that we picked up, like members of our group felt that the counting process in these small venues, they are not very transparent and there's room for manipulation. Because they are so small, some of them have only like 200 voters or less, and there's like more than 1,000 polling venues. So political parties are not able to send their party agents to each of these counting venues. And in fact, when we're doing a project in 2014 as part of the NGO coalition, I had been to some of these small polling stations, and sometimes there's not even one party agent present. Okay, so that's why they're saying that instead of counting at these small polling stations, they should be brought over to the district officer's office or the regional office that's there. All the ballot boxes, after the vote has finished, the presiding officer can tally the votes, they can sign all the documents about how much votes were cast, etc. And the sealed ballot boxes are to be brought over to the district offices or regional office, where there's a lot of party agents and other observers are there who can observe the counting process, like was done in 2006 elections, for example. Those of you who were around at the time, I know we have many younger generations. Okay, so yes. And also, if the intent is clear, the ballot should be counted. So if in any way it's quite clear that only one choice has been marked, that vote should be counted. The other weakness we noted were the excessive fines and penalties, fines of up till $5,000 or $10,000, penalties you can go to jail for 5 to 10 years. That's too high. That's it's a human right. We have a human right where it's part of our human right to stand in elections, for example, or at the least to cast a vote. And these kind of high penalties actually make people fearful of standing for elections, because there's so many offenses and the penalties are so high. And so we feel that that's actually a deterrent on people being able to enjoy their right to vote, their right to form political parties, and their right to stand in elections. And also, at the polling centers, the decision of the presiding officer, it says is final. I saw that we saw that in 2-3 places, and how can something be, they can just say it's final, you know? And in so many of the acts, they say, for example, the decision of the supervisor shall be final, you know? Because if we have a court that's in our country and people have a right to a fair trial, you know, there should always be some room to take the issue up. In this case, probably, if the party agents, for example, we know, feel unhappy with the count, they can appeal to the supervisor of elections, and the supervisor of election can do a recount, though it does say that the supervisor of elections can order a recount. But that kind of contradicts this point where it says the presiding officer's decision is final. If the supervisor can order a recount, which is on page 1, and then a few pages later it says the presiding officer's decision is final, that's contradictory. Yeah, so the strengths, we did find that there were some strengths to the act, and that's maybe the inbuilt accountability measures that were there. I wouldn't go into the details, but we'll just leave it there. Thank you.
Okay, so let me respond. If you can please keep the camera trained on that. Okay, so the first proposal that you make here, check. So essentially, what you are saying that you want the ballot boxes to be transported from the voting venue, polling venue, to a count center. Now that is hugely problematic. You know, if you have had experience with the previous elections when this was done, there are many allegations, and some of them are very credible allegations of ballot stuffing and all of that along the way, right? What we have now is one of the most transparent electoral processes in the world. Right? I used to be very critical of it, but we also had so many interactions with multinational observer groups that have been coming to observe elections in Fiji, and I've had people with 25, 30 years of experience observing elections, saying to me that the processes that we have in Fiji is one of the most transparent in the entire world. From the time that the first ballot is cast to the time that voting ends, the ballot boxes are opened, they are tallied and counted, the ballot box is in full view of everybody, party agents. I don't think it is an excuse that party agents cannot have people at 10,000 polling stations. This is a nationwide election. You should be able to organize to that extent. Right? And the other thing is that all the polling day workers are recruited through an open process, through a merit-based process. So for them to be, manipulating the votes, all of them need to be in the game, all of them, right? So right from the time that the first ballot is cast to the time that it is opened and counted, the ballot box is in full view of everybody else. So there's absolutely no scope for funny business. So that's why, all the parties that have made allegations of vote rigging in the past 3 elections, none of them have been able to substantiate it. Forget about substantiating. None of them have been able to come up with credible theories of how it could have been done, because it is impossible to do it. It's there, unless you have magicians or all of that. The other point that you've put in there about manual count. Now, I want to clarify this, because this thing about manual count, manual tallying, this continues to pop up. The reality is that all the counting that happens is manual. Right? If you're aware of how ballots are counted in Fiji, there's nothing such as electronic counting. Right? It's all manual. What happens, after voting concludes, that ballot box is verified. So there would be reconciliation of the seals that have been placed at the ballot box. All the ballot boxes are, all the ballots are emptied on the table. The polling officer will show to all the candidates, the agents in the station, that look, the box is empty. And it's also a clear box, transparent box, compared to the past when we had opaque boxes. And so it's very easy to see that there's nothing there at the bottom of the barrel. And then when that happens, there's the tallying that happens. So they will hold up each vote, say, okay, this vote has been cast for this number. So it will go into that row. Right? And there's also opportunities for polling agents that differ about whether the intent of the voter is not clear on that ballot. So you can even dispute that. Right? So there's no electronic counting. Please, I want to make this point very clear. There's also the only place where computers come into play is in tallying. So there's no sophisticated software. People have been saying, oh, there's a software that has been procured from NADRA and it is manipulating the votes. Right? There's enough mechanisms in the system for people to catch that if anything like that is happening. Right? Because the protocol of results, which is filled in by the presiding officer, it is completed in triplicate. A copy of that is pasted outside the polling station. And there it is for public consumption. Anybody, you can take a photo of that and then you verify it against the final results that are released. So there's absolutely no scope. Right? We are also skeptical of it. I tell you, back in 2024, we studied the process carefully, and there's no scope for any funny business. That's how, yes. Yes.
Thank you. Samuela from Unity Fiji. Go back to that election, the last election, where there was a glitch in the machine. You must mention that. And secondly, another glitch. The people of Fiji were supposed to be told what happened.
Okay.
I just mentioned what the supervisor of election did. They said they're going to do the manual count. The manual count is supposed to data to be put it into the management information system. We believe it will take maybe 3 to 4 hours to come up with a result. But that data was preceded by his announcement to be official. And I think that's probably something that we need to certify or that address that needs to be done. But that was not done. The government, the parties agreed to tell us the report of the glitch. But as soon as they got into the government, they forgot about it.
Okay.
So the people were left with their skeptical views. And I think it's...
Okay, yeah, thank you. The glitch that happened at the time of the 2022 election, actually on the night of the elections, after a few hours into the counting, that happened with the FEO app. The FEO app is a reporting app. It is not a tool that is used to tally votes. It is for reporting purposes, right? And apparently, I mean, this current government hasn't also revealed, I think they did investigations, but they haven't revealed what actually went wrong with the app. But for some reasons, there were vote tallies of certain candidates that got inflated. And there were unrealistic results showing for some candidates. Everybody were surprised, including those candidates themselves, right? But it doesn't really affect the official tallying process, right? As I've said, the counting is done at the polling stations. So what happens after that counting is done, polling agents agree, everybody signs off on the protocol of results, and then the presiding officer calls up the National Tally Center, which is in Suva. So they would be telephoning and conveying the results. That okay, 153 has received this number of votes, 168 has received this number of votes. Now there are two people sitting at the National Tally Center in Suva who would be doing blind entries of those telephoned in results. Once those two entries reconcile, they put it on the app. They also put it in the provisional reporting spreadsheet, right? And that result is released. Now a lot of people also have problems with the fact that provisional results are being released. They call it provisional because the Office of the Supervisor of Elections hasn't received the original copy of the protocol of results. It has been found in result, hence it is called provisional, right? Because there's another layer of verification that happens before they announce the official results. Now some people have a problem with provisional results getting announced. I tell you, once the pink slips, which is the protocol of results, copy, becomes public, that result has become public. Imagine if there wasn't an official source announcing those results, right? People would be taking photos of those pink slips, they'd be doing manipulations, they'd be editing it, and they'd be putting it all over social media. And that would, create a lot of confusion, that would create a lot of doubts about those results. So to avoid that, especially given the results are out there in the public domain, that is why an official entity needs to be releasing those results, right? Because those results, remember, are public the minute they are confirmed at the polling station. Yes.
So, just one question on the glitch itself. Okay, manual counting, 100% you correct. It was manually counted from polling station all around country, sent electronically to the central counting center, again, manual counting. Am I right? Am I correct on that? Manual counting from outer station, manual counting in the central counting station, again. So they totaled up, manually done, manually counting. It was done. Okay. The glitch comes after the national counting was done.
No.
Before it goes into the computer system by two experts from overseas who are here in Fiji. And they call it a double-blind data entry. One will enter first, the second one will enter second, one after another, the same result from the manual counting number. So, before this thing goes to the computer, the result, the winner already known. Thank you.
The glitch happened on the night of the elections, 14 December. at around 9 p.m. So it did not happen after the announcement of the final results. Professor Frenkel, you wanted to add something? Can you get him a mic, please?
Yeah, one thing most people will be familiar with the Fiji system, but perhaps not everyone. But one peculiar thing about the terminology is that the Fiji system uses the term polling station to refer to ballot box, effectively, and polling venue to refer to what elsewhere we would normally call a polling station. And I've read these carefully for the 14, 18, and 22 election. Very grateful to have disaggregated results for, I think it's 1,440 polling boxes or something like that, what are called polling stations, which are ballot boxes. I can't remember the exact figure. It was very interesting from the point of view of political science, but in practical terms, the reason why they did that was so that they could micro-observe how electoral loyalties were moving at the very, very local level. And there are examples of punishment meted out to certain villages that were known to be voting the wrong way. I found that got a bit more difficult a little bit later, and some of the things that were happening on Kandavu kind of changed a bit. But I also thought there was no evidence of rigging, by the way, and came out publicly after all of those elections saying that I didn't think there was evidence of rigging in the sense of stuffing ballots into boxes. In the wider sense of controlling the electoral environment, there was a hell of a lot of manipulation of media, candidacy, disqualifying people. I actually wondered whether this wasn't a global trend to keep your elections absolutely squeaky clean on election day, but constrain the wider environment to such a degree that you're really not creating a level playing field. Secondly, Mosmi's point about the decision of the president being final, supervisor having the capacity to order recounts. I mean, I don't know the detail here, but presumably the decision of the presiding officer would be final over issues like the validity of the ballot. And anyway, there aren't many invalid ballots, or whether someone could how they cast a ballot. But recounts, if I remember rightly, are statutorily required if the result is within 0.5% of the leading parties are that kind of close, so that's slightly different. Although I agree with you about the issues of higher penalties and some of the other things. On the glitch, which seems to be a subject of considerable debate, yes, what you're saying, Nilesh, sounds very familiar because it was the explanation put out by the former Attorney General and the supervisor of elections, and I know what you mean. Yes, it's true that the provisional count was based on these pink slips that were phoned in to the supervisor's office, and then we got those announcements, and then in a sense there were glitches after all three elections, simply because it was a daft way of doing it to announce the results up to 50 to 75% of the total on the basis of the provisional results and then start from scratch over again. It was tailor-made to make often illogical and unfounded allegations of fraud. I was here in 2014, combined with what the multinational observer groups did. In 2014, I was here on that day when they started the count, and the multinational observers called a press conference at the Grand Pacific Hotel at 4 o'clock that afternoon. And in response, the opposition called a press conference down outside the FMF Dome. I went down there to listen to that. It was Mahendra Chowdhury was there, Linda, I can't remember who else. They were all there, and they all came out with premature allegations of electoral fraud because they were competing with the multinational observer groups, who were all going to say this is substantially in line with the will of the people. And it was in the middle of this awful provisional account. Oh, sorry, the provisional count, I think, had stopped at that stage, which set off all sorts of alarm bells. Now, I've recommended to this method of partially counting the provisional ballots and then starting the recount using the official ballots was transformed into law. At first, it was just a method of administration, but it was passed into law by the 2022 Electoral Amendment Act. IRSAD codified it basically and made that the only way to do it. I argued strongly against it, and I've put among other recommendations, a submission to the Fatiaki Commission suggesting that Fatiaki-led commission suggesting that if they insist on keeping that law, what they should do is announce the provisional count together with the polling stations from which they're counted. That's what they don't do. They do it in the aggregate, so no one can check afterwards whether there are inaccuracies that emerge. If you did it, and I know for a fact, because 2 former electoral commissioners have told me that the reason why they don't do that is because the former supervisor of elections like to have a little bit of freedom of manoeuvre just to make absolutely sure everything added up at the end and move things.
Well, in relation to the last claim that you've made, that is not so. The provisional results are released according to polling station or ballot box, as you say. So there's always scope for anybody to verify those. So you can always verify that against the pink slips, which are already public. So there's a lot of misconceptions about some of these things, but there's enough mechanisms within the system for verification. Now, in relation to the other point that you made about the difference between polling venue and polling station, I think there's a very good rationale for that. The reason for having multiple polling stations at a polling venue, so for instance, if you take Rishikul College, it is saving a pretty large area. So in order to improve accessibility and also to ensure that each polling station has less than 500 voters, they need to have multiple polling stations at that polling venue, which is Rishikul College, for example. Right? Hence, the need to differentiate between polling venue and polling station in Fiji's case. You can equate a polling station to mean ballot box, but it actually means a station, a polling station. And there are multiple polling stations. For instance, there might be 7, 8 polling stations that are set up at that venue, Rishikul College, for instance. So that is the difference. Ellen, you wanted to intervene? Yes.
Just a couple of things. International good practice would be that all ballot boxes at the one venue are counted together, not counted separately. International good practice would be that ballots are counted as close as possible to the place in which they are actually lodged rather than transported. But that's what I really wanted to talk about, is this whole issue of disputes. Some countries, and particularly those that have a 2-part election management body, have another dispute resolution mechanism rather than just a recount. And what they do is that if the agents cannot agree with the polling, with the presiding officer on the validity of a ballot at the polling centre, that goes out separately into what they call a challenged ballot sort of package. And those challenged packages go to the election commission for decision, for final decision. So the presiding officer does not have the final decision. So that circumvents the need to take everything to a judicial remedy, which can be A, difficult, B, long-winded, and C, very lengthy to get a resolution. So that might be something you want to consider, that if it isn't agreement about the ballot, that the presiding officer then puts that ballot aside and it's the election commission that determines its validity on it. You don't want thousands of these, but often there's only in the couple of hundreds of these in countries this size to determine nationally.
Just some information. In terms of the glitch has already been approved that that was a human error, and that is the reason they had to destroy the last ballot papers just a couple of months ago. Secondly, the double blind is not a human. The double blind is a system. It is 2 different lines where there's systems, and you put the same documents on the same document, and then it scans it. It's called an OCR. It's like when you fax and text, it captures the things on the paper and then puts it up. And if the same scan is the same,
That is what we call double blind. You bring it together and it takes away the blind. And in terms of what the man is saying, the supervisor of election checks the challenged ballot papers at the polling stations. This is to, locally we've agreed to this. All the parties sit down on the whole year. We have certain meetings, and then we agree to what happens. When you have bigger things, then it's taken to the tribunal. In terms of 2018, that's what happened. We took the count to the tribunal, which NFP was supposed to have one more seat, but the case was withdrawn. So exactly how they're explaining is exactly how it happens. From the polling stations, there's only 500 ballots that's supposed to be in that box. The reason we have multiple stations in that venue is that that place might have 2,000. That means that's 4 polling stations. That's 500, 500, 500. So makes it 2,000. So just to keep it a thing, most of these ideas are in discussion and with the elections office. And when you're a political party, you are invited to these discussions. Thank you.
Thank you, Mr. Takayawa.
Just one short point to add. There was something else we discussed, but it's kind of missed out being listed here. So we had been discussing our own experiences because most of the people on our table had been part of political parties, so they had been observers. So in my case, I just think it's important for me to share this experience. In 2014, we were part of this Concerned Citizens for Credible Elections project, and we are trying to observe elections. And I was allocated this area, Princess Road, Samambula area. And I went to this polling station. I believe there was no polling agent there. And in fact, the area I was allocated, they're very small stations with just a few hundred voters, and hardly any polling agents were there. And so I went there and I told them I was just here as an observer, a concerned citizen, and they even asked for my ID, which I showed, that I'm a Fiji citizen, a registered voter. And then what happened is that the police started following me around, I was driving in my car and they kept following me to the next station. And then that station, one of them was closed. They locked the gate so no one could enter to observe the counting. That primary school up Princess Road, Khalsa Road at the junction, the gate was locked. We couldn't see how the counting was going on. They were not allowing anything. And the police were even more concerned, why am I trying to find out what's going in there? Then they followed me right up to the Cunningham Street polling station, which was a huge polling venue. There were thousands of voters and the count was going on. For a few hours. When we left, it was still going on. And once I decided the count will take forever, and it had a lot of party agents because it was a big polling venue, I decided to leave for home. The police also were relieved because maybe they felt they didn't need to follow me anymore. But I mean, how are we as concerned citizens going to monitor and hold the election process accountable if they follow us around, they ask us such kind of questions, and intimidate us, because in the case of these very small polling stations where no party agents were there, people like us, I was not trying to squeeze in and take the place of a party agent. I was outside, I was not in the official areas, outside there looking from far away. So, what harm can that do? There needs to be room for citizens to be able to do this kind of observation without police officers following them around, asking them for ID, intimidating them in such ways. Yes, thank you.
Well, the authorities at that time were quite paranoid about a lot of things. But when it comes to security concerns on election day, safeguarding the security of the counting process, that is again a valid concern, because you can't just have anybody go in and observe. Otherwise, imagine if 20 people mob come in and then they demand that they want to observe the counting happen. So that's why only people that have been officially nominated by political parties can enter polling stations and observe the counting. Anyway, so we'll proceed to the next. Yes, very quickly. You'll have a minute.
Also on that, my name is Vernik Saturanga. Also on that, I was a candidate in 2022 general election. I wasn't allowed to come in at the time of everybody was there. I have to come on a special time where the venue is empty. Just for safety and security, I think that would better clarify the situation with the ma'am. At that point in time, I came in early. People were lining up outside waiting for the gates to open. So I was told I have to go back home, wait for the lines to go down, then I can come after. So I do not be a conflict of interest for people that come to vote in my area. So I think on that note too, we must know that the safety and security of what is happening inside. So we are not supposed to cross it, or I cannot even go and help someone that got off a taxi and could not stand and walk properly. To that point, I could not do that because it will be a conflict of interest for people that are deciding to vote for somebody and saw me doing a good deed and then they change their mind and then voted for me. It's like a campaign within the blackout period. Thank you very much.
Thank you very much. We'll move to the next group, and I believe Veronique's group is coming up. Thank you very much. Very good suggestion. What we will need to do though is to have it one by one, because the gentleman doing the validation would not be able to, keep all of that in mind. May I ask the groups, when you present, to have one presenter and to be very fast about what we are discussing about, and to other people questioning to maybe stick to questions. Okay.
I think Dialogue Fiji, let me make it very clear, we have a principal stance about propagating misinformation. So we don't want to create a forum where misinformation is propagated. So when we see misinformation out there, right, we intervene. Okay. Yeah, so what, yeah, I think it's countering misinformation is very, very important as well. Right?
All right, so we'll have group 3. Thank you very much. Group 3, you can start right away.
Thank you. Sorry, we won't be projecting anything. We had some technical difficulties. Don't rely on technology much nowadays. I'll go to the old system of doing things. We're supposed to have the paper. We relied on technology. We just leave it there. So first of all, I would like to say something in regards to what we were given to use in order to present, right? Before that, my name is Vipin Maharaj, the General Secretary of UNE Fiji. This particular document provided to us was inaccurate and incorrect, right? And this is the document that was given to our table. When we match this to the real legislation, the numbering of the sections is inaccurate, right? What we see here is section 31, in the real legislation is section 35. So when we make submissions, this is just for everybody, when you please do cross-check your legislation, so because when we make submissions, we don't write the whole section. Sometimes we just say section 31, this is what we want amended. So before you give out any piece of legislation for anybody to read, make sure you do your due diligence to counter that misinformation, because this piece of document here, for Electoral Act Division 3, it's wrong. Right? So we won't use that document. Now, as per my group's research, right, we did have some strengths We did have some weaknesses. We'll not offer any recommendations. So here are the few strengths that we found out was one, many a times people have been talking about the draconian penalties that are in the Electoral Act, right? We have seen it all too many times. We have seen it on online media, right, that there are draconian penalties. However, let it be reminded, and there are legal professionals in the house who can correct me if I'm wrong, I'm still learning, but the high threshold of penalty was put in place to be a deterrence, rather than that to be a fine. Because, let's say for example, if you go to the Crimes Act or go to penalty for rape, the imprisonment is life imprisonment, but when you see the actual court cases, they are 16 years, 17 years, 14 years. So that $50,000 fine, 5-year imprisonment, that's not the maximum, that's not, that every time you make an offense, that's the maximum you'll get. Or that is the exact fine you'll get. No, that's a guideline. That's a maximum cap. That when courts punish you, they will not go beyond that. The initial intention of that law to be there was to act as a deterrence, not to act as, well, yes, we need to put the fear of God and law in people at times. Otherwise, without laws, we are just running in chaos. Right? Another strength we found was the electoral integrity. Right? The ballot has security features, whereby it was mentioned before that none of the ballots can be photocopied at any other place except for the place that it was being printed. So that is one of the strengths we found. The other one was pre and post distribution of ballots, which is in compliance with the international best practices outlined in the Venice Commission Code of Conduct. Right, that's one thing. And these are some small strengths, such as use of indelible ink. This is because, so that no one person be allowed to vote twice or thrice. So those were that. Some of the weaknesses we found was the over-concentration of discretionary powers to the SOE. Right? They have the ability to register and deregister parties, right? And they have the power to have the final say on any electoral matters. There's also, another weakness is the 48-hour ban. In a country with almost 930,000 population, less than 1 million population, that 48-hour ban, in our opinion, should not be there. Because you spend months and months of campaigning, hundreds and thousands of dollars in campaign material, and then you have 48 hours to take it all down and be completely gone from the media, and then completely gone from the face of the earth. You cannot be seen anywhere. Even if there's a small poster in someone's shop that says your political party's insignia or name, there you go. Bye-bye. But that is why we are saying in a country that is so small, we do not need that 48-hour ban. We also have to be mindful of the smaller parties, as well as the funding cap on individuals. So, and the independence as well. You do not get enough funding to remove all the materials you have used. If you use 100,000, you need another set of 100,000 to start removing everything, pay people to remove everything. Right, so that is just some things from our end. Thank you.
Thank you very much. I hope that all of us presenting after this, or have you already presented, just to straighten up that part of the legislation, because of the things that we have to do, because the sections that are stated out, it should be correct. You have to do your groundwork, and this is where misinformation and everything happens, and everybody must be careful so we don't take a wrong step. Otherwise, you're referring into one section of the law, and the actual section is on the other end. So that means your suggestion will go straight to the mailing bin. That's just all for today. We are thankful that this has happened, and we come to it. And we also wanted to post a very a very serious question for us today. I think we've been trying to post this question so many times, but we were unsuccessful. The first question is, how practical is this electoral reform? since the director stated that they are going to submit on the 30th of June. On the 28th of June, we have the budget announcement. So after that, you will have to wait for another budget year to secure the funds to do the reform. That leaves us with 4 to 5 or 6 months to the next general election. How well will the people receive all the reforms that we want to make? Thank you very much.
Just a couple of things. In terms of the concentration of discretionary powers in the supervisor of elections, in most places where you have a two-part electoral commission, an independent body and a departmental body, the final decisions are made by the Electoral Commission, not by the Supervisor of Elections. And this gets to this point about deciding challenge ballots as well. Sending them to the Supervisor of Elections is like asking someone to mark their own homework. It's basically useless. You've got to send it to the Independent Electoral Commission for anything challenged, not the Supervisor. So that concentration of powers, I think, is an issue. Second thing is, just briefly on the penalties. Yeah, okay, they may be the upper limit, but they can still be imposed. And they are draconian at their upper limit. The other thing about the penalties is they tend to conflate the criminal with the administrative. And everything is treated as though it's a criminal offence. And that is not the case in most electoral jurisdictions. So I think that both those things would be well looked at in Fiji. What's criminal, what's administrative, and what is a proportionate penalty for the offence, rather than a maximum that you could possibly impose.
Thank you. The next group is ready to come. Thank you.
Okay, Vinaka, ladies and gentlemen, we've heard from the last group about what we have with us. We are not going to be deterred by what's been said, but we will go ahead, okay? So we'll be speaking on the conduct of elections, and we couldn't finish everything, but whatever we have here, we're going to be sharing the information that we need to be sharing this afternoon with Mr. Satish Kumar. And the first is the conduct of elections, and Division 1 is to read. Our thought was on the weakness of the read is in subsection 3.3, and it says the Electoral Commission may conduct postal and pre-poll voting in the days preceding polling day. We believe maybe it should come down to the supervisor of election, and also the wording, the may. I believe the words that's used in legislation could distort what needs to be done. And in this case, I believe this legislation was done before most of our citizens had gone abroad under the neck to work. So therefore it needs to be reconsidered again in regards to the postal and the pre-polling, as we've also heard from Miss Billings when she went to India and then when she got back again. And the other thing that we have here is in Division 2, and it's regard to the candidates who are public officers. I know that Mr. Kumar will also talk about the public officers, because they are not only public officers. I believe some of them are civil servants Or are they also, if you're a civil servant, are you also a public officer? And that particular subsection, it needs to be enforced, because some of them still hold their job and they're still driving a government vehicle, and while holding their jobs, they are also doing campaign using government money, whereas political parties, I believe if they are caught doing that, other political parties, if they're caught doing that, they will definitely be fined, or they will be put into task. So for subsections 1, 2, and 3, it applies that that is a weakness of the last administration. I don't know how it will go for this administration for the next upcoming general election. For the nominations of party candidates, the rejections of nominations, that was one of the weakness that we did encounter in the last 2022 general election. And it goes hand in hand with the 1,000, the deposit and the statement of supports, the $1,000 that was paid. What we saw was there was nothing in the legislation that talks about the refunding of the 1,000 that was paid by whoever was nominated. So that need to be looked at. We don't have any recommendations just yet, but it was definitely disheartening to see that whoever was nominated, when it got to the supervisor of elections, then they were not accepted. So I will let Mr. Kumar continue from here.
Yes, thank you. Just to elaborate on the $1,000 deposit fee, it seems that the Fijian Elections Office has become a money-making body. I mean, if you are feeding 55 candidates, you're talking about just paying a fee of $55,000 at the time of registration of your candidates when you are nominating them. So that's too much. The fee itself is too much to look into for a country with the economic background that we have. And that fee is passed on to the candidates. And at a time when candidates struggle with the massive expenditure outreaching, and you have to bear in mind a single constituency, so you have to campaign throughout the nation, unlike in the past where you were restricted to one particular district, and that's your focus. Here, when the single constituency, the whole nation has to be taken into account. It's a massive expense for individual candidate to outreach, and the cost of media and advertising, billboards, and all those is massive. And yet we are to pay $1,000 for nomination. And then we have individual independent candidates. They are, apart from the same fee of $1,000, they are required to have 1,000 registered voters' signatures to endorse them. That's a bit too much. Looking into the results of some of the candidates who enter parliament, they don't have even a couple of hundred votes. And here we are required to have 1,000 votes for independent. That's a voter support. So we have to look into this type of arrangements there. Then in terms of nomination for party candidates, we picked up the issue on number 2. It says the total number of candidates which a political party may nominate for any general election must not be more than the total number of seats in parliament. On the face value, fair enough. What if you have closed the nomination and some of your nominated candidates are ruled out, objections? So rather than 55, last minute you're told 3 candidates are disqualified. Can there be some provisions like reserved candidates? In case last minute, if there is somebody who has been disqualified, then you have already people in the queue to fill that gap at the 11th hour. Because at the end of the day, the whole voting system, every candidate's votes matter. Because it adds to the party vote bank. So even the last candidate you have gets 200 votes, that will make a difference to the party standing at the end of the day. And then they say on section 3, part B, rank candidates in the party list. Fair enough. Whose discretion? Party leader? Party management? It doesn't spell out. So there can be room for favoritism, as my preferred list is this. Or can it be fair? It has to be in alphabetical order. Or what is the criteria? It's silent. Then on 5, it says, party list must include a certificate certifying that the order of candidates was agreed to in accordance with the rules of procedures of the political party. What if that is not stipulated in the party? It's silent. You have seen some parties took their own party constitution to court, their interpretation and so forth. What if these provisions are not there? Because at the point of registering a party, it doesn't stipulate, like there is a provision, you must have X number of people supporting your registration from each of the 4 districts. Fair enough. But in terms of spelling out the procedures for such practice, it's silent. What happens then? There was also a lengthy debate on within our group. We exercised our democratic right to hear everyone. On 4A, yes, in terms of a person's eligibility to be nominated as a candidate for election in parliament, only if A says is a citizen of Fiji and does not hold citizenship of any other country. Very interestingly, the first part is good. If the country allows dual citizenship, what is the fault of the citizen? We recognize dual citizenship. And you penalize somebody for holding Fijian passport at the same time any other country's passport of his or her choice. That's grossly unfair. You have Fijian passport, you are a Fiji citizen, you should be allowed to contest. Bottom line. No discrimination in terms of any other provisions. Otherwise, you change your dual citizenship requirement. C says, is ordinary resident of Fiji for at least 2 years immediately before being nominated. What is the motive of this legislation? If I go for my studies to do my PhD, in last 3 years I'm out, I'm done with this year, and next year I want to contest, why should I be disallowed? I'm working for a multinational company, and my employer says, can you be transferred to PNG or Samoa or Tonga or Vanuatu? Why should I be discriminated my right to contest? And then E says, is not a member of Electoral Commission and has not been a member of that commission at the time during the last 4 years immediately before. I think it's too much to ask. They are very independent. If politicians sitting in the office till the last day or even when the elections is happening are never regulated to be out, why penalize somebody who has been in a neutral space? And likewise, it exempts government officials who are out for duty. And as I said earlier, you have a rule that exempts government officials like on diplomatic duties and other national duties abroad. But at the same time, private sectors, or now in a global village that we live in, there are many who move in and out for official duties in the private sector too. Multinational employers, transnational corporations. So why different rule for them? One set of rules for government officials, another set of rules for all others.
Mr. Kumar.
It's not fair.
We are running short on time a little bit. Sorry to interject.
Yeah, the legislation never ends, so we have to continue. I stop there. Probably we can have space for more discussions. Otherwise, if you want to complete, we can be here whole
Definitely,
day.
definitely.
Thank you.
Thank you for that. Group number 9, are we ready to go? Naka, let's have it. We'll give 5 minutes for the presentation. 2 minutes. Thank you very much, Salote. She's very fast.
We are here for reform, so we would like you to hear the reform we discuss. The strength and the weakness has been well diagnosed, but this is the reform that we have come up with, hearing the information from yesterday, today, and seeing how our Fiji is evolving. We appreciate the information from other countries that has led us to trying to define something that will not be one-sided or the other. So we're suggesting we go back to constituency, not the old constituency boundary, but what it is now. So we still recognize the provinces, the municipals, but we need to add the district advisory council, because most of our people have moved. And this also involves the informal settlements who are not addressed in the current parliament system and or legislative. Okay, it's not considering their needs. So what we're suggesting with the Fiji balanced representation, 3 reps for each party. Mr. Wall had talked about this. Right now, only 1 member per party per constituency. We are suggesting that you allow the voters to vote for a man, a woman, or a youth, and they prioritize by voter who they want instead of the reserve seating. Okay, that settles that. And so we'll come up with 45 seats from the voting, which leaves 10. Instead of calling it an open seat, these are special seats. These seats address the need that the results of the election makes. So if there is no representative with the disability community and all these other minorities, or there's need to be more women, then we pull from what the voters have prioritized in their voting. I know some of you might be confused, but don't be, because this system strengthens democracy, human rights, and social cohesion. Now it's your job, all those of you who are lawyers and that want to take time to write policies, if you need to match what the people want and not just do your thing and give it to us. We need to go from bottom up. And these 2 lovely men want to join in the last minute. Half for you, half for you. Thank you for supporting women.
Thank you, Charlotte. Right, I had a look at objectives of this workshop, and I didn't see any identification of legal, to identify that legal, to give us the power to follow up, to chase, and to action. And then maybe that is one area that we need to look at these objectives. I think, if I'm correct, you mentioned something about following up until it is done, because of the limited time. So we can make this thing work. If you identify that legal, maybe the legal people can also contribute in that manner. We identify that legal to give us the power to follow up and make sure that it is implemented. I had a chat with Mr. Hall yesterday regarding one act in another different country to allow coalition before the election, and if that can be considered too in this workshop. Thank you.
Of course, sir. Yeah, sure.
I'm here to answer any question. Please don't ask anything. What is your suggestion, members? Something new, eh? Is it eye-opening or is it foolish presentation or what? I think this is a one vote, one value, one count, or what you call it. It represents everyone, all. It's your choice.
Just on your 15 provinces, is it leaning towards more on the Itoke side or?
No. Only one. Only one rep from the three. Men who in that province, whichever they will vote to represent that province, whether it's a man, one from maybe a lady or a youth.
Provinces. Is that including Ratuma, or is it the new one that GCC wants to bring about?
Yeah, GCC stays out of the government. That's their role because they look after. Yes. We're talking about the government. Yeah.
Province, but you are in towns. That's 13 municipals. That's you in Suba. And we have our squatter settlements. Settlements all around the town. This is Fiji, and we understand. Everybody understands that. They have a vote. They have 17 to pick out from. This is fair. If the legal drafters are here and the experts are here with us, I think this is what Group 9 comes up with, if you can take it into consideration.
Sure. When the previous question about the ethnic balance is relevant here, surely because of the provinces, the Fiji Indians are a majority. It would be in Ba and Mathuata, and it's skewed very heavily towards the indigenous population. And you have the advisory councils. I mean, it's like the provincial, like the rural system, but adding in the municipal councils into that, because the Fiji Indian population historically didn't have rural representation in Fiji. They only had the ancillary position of the advisory councils to the provincial councils.
It's all there. They will be represented. It's there.
Right, that's clarified.
Any other no?
Thank you very much. Thank you very much. We can.
So, with the plan that Group 9 you put up here, that considered us on the 2013 Constitution that we are all Fijian and we fall under one category? Oh, thank you very much. Thank you, Unity Fiji. The answer.
Thank you very much. Group 8. Group 8, if I can have you here. We're going to have to be very fast. We're running very much out of time. So we're going to have to drop it down to 3 minutes to do your presentation. Stick to the main points. And those asking questions, be very quick about it. So we would rather have questions than observations or statements. Can we maybe stick to that so we can have presentations for everybody? Brilliant. Let's go, Group 8.
Hi all. Today we are talking about strengths. Number one point is enhanced transparency. So this occurs when an act mandates that political party discloses their assets, liabilities, financial records, making their operations more open to the public. Number two is modernization of political party management. That's one of the strengths as well. So the Act introduced a more modern and efficient process for registering and managing political parties, ensuring they operate within legal and transparent guidelines. Number three is reduce risk of illegal activities. That is very important. So when we talk about illegal activities, by setting clear rules for political parties, the act that helps prevent illegal and unethical practices such as undisclosed funding and campaign violations. Number three is it promotes public interests. So when it comes to public interest, the Act's provisions for disclosure and accountability are crucial for ensuring that political parties operate in a way that benefits the public interest and not just their own self-serving agendas. And lastly, promotes good governance. That is very, very important. So the Act contributes to good governance by promoting accountability, transparency within the political system. And now we'll be talking about weaknesses. I'll give it to my colleague to answer that.
Hi, I'm Ranjana. We got a few points on weakness. One of them is potential misuse. Second one is limited accountability and transparency. The third one we found was like it was very strict. Example, part 2 of section 3 to 24. And then at what, 2A? It was 2A?
2A.
I can't see my glasses there.
I'm sorry.
Section 2A.
Part 2, section 3, 2A.
2A, yes. Sorry for that. And now I give it to my colleague to conclude. My glasses contacted.
Now, I wish to pose this question for recommendation. Gender balance for every political parties, is it in reality or is it just on paper? Some parties are saying, in reality, what about other parties, political parties? Because if we have this at political party level, we can have that at national level as well. So I encourage other political parties that are not having this in reality, but just in paper, you have that, okay, gender balance, but in reality, so I need to pose that, and we need to have that in reality in political party level. And this colleague of mine, Kaur, this is what she went through. If a new party is going for registration have been declined, in actual fact, nothing is refunded back to you. So we are recommending at least 1/3 of the 5,000 to be refunded. We know all the administration costs will be there, but at least 1/3 of 5,000 that you paid should, if it's declined, 1/3 should be refunded. Thank you.
It should at least.
Thank you. Since there are no more comments on this one, the next, Mr. Takaya's group.
Okay, my name is Lai Rongwewa. I'm part of the Fiji Human Rights Commission. I'm going to not be talking a lot about this. I'm just here as an observer. My friend here, Mr. Takaya, was going to be talking about the issue before us on political parties. So there was another party that was supposed to be part of this discussion that we have left, the gentleman who left. Namely the NFP and academia from USP. So notice that we agree as a group that this particular document has to be reviewed. That is not my head as a human rights advocate, but as a personal person, as a citizen of the country. Naka.
Thank you. Again, this is not my disclaimer. It's not a party, or it's a part of the group, and those two actually are supposed to be doing this, but they ran away. So we agree that we have to review the... First of all, the strengths. We think that the Political Parties Act is a good, transparent, and good governance in its form. We also believe that the strength is reporting, given the structures to all the political parties to follow as a guideline, so that we keep everything formal. The weaknesses, funding. There's no clear guideline on the small parties to have funds. They are more inclined to the bigger parties. This meaning that most of the people would like to give money to the bigger parties because they have access to government facilities, rather than the smaller ones who do not have that capabilities. This one is especially from NFP. He was supposed to come and see it, but deregistered parties, there should be a provision for the creditors to acquire the funds they owe to them. This is specifically for Fiji First. When they owe money to the Fiji First, the elections office should try and recover the money. But he's not here, so he was supposed to explain more on that. The refusal to register under section 2, 10, 2, 3, 2 and 3. Eh? Our recommendation is there's no clear guideline to that amend the act. The registration of the parties, again, we think that something needs to be, is the same thing, the creditors. Reduce the registers, political parties registers power. He seems to come up before the election and then disappears after the election. It's just that we need some kind of standard. Thank you, that's all we have. Question,
you.
can direct it to Chair.
Thank you very much. Oh. are we done with the first round for everybody? Brilliant. We want to move on to the second round? And whoever's ready, I believe Dr. Bhim. Yeah. We'll give you 3 minutes.
Good afternoon, everyone. So we were given the task to look at the Political Parties Registration Act. Oh, and I'm happy with it because the Electoral Commission wanted us to look at it too, but I didn't look at it very much in detail until today. So I tried to organize it into those 3 columns: strengths, weaknesses, and recommendations. So the provisions to do with audit, the registration requirements of political parties, we think these are strengths. The code of conduct for parties is also good, particularly section 6, for example, where it makes an obligation on parties not to incite racial hatred or violence. So those things are good because if they want to run the country, we must ensure that they respect human rights, you know. For example, weaknesses, these are just a few of the weaknesses that we found in the Act. Firstly, the excessive fines for unregistered parties and the media. We found in the Act there are fines of up to $5,000, $10,000, and $50,000, and imprisonment for 5 to 10 years. So we understand, as explained by other participants, that's supposed to be the maximum. The maximum is too high. The maximum should really be kept to a minimum so that it does not discourage people from participating in elections. So maximum should not be like so high that it makes people feel scared to stand in elections. We feel that these excessive fines for unregistered parties, people who want to register as a party, and for the media as well, under that section, violates freedom of assembly and association. If you're unable to register as a party, you should not be prevented to gather as individuals and discuss issues. Just because they do not want to register you as a party, they shouldn't be fining you or charging you if you want to assemble together and discuss, because that's a violation of human rights, right to freedom of assembly and association, and also freedom of expression as well. There's also those who have been jailed for 6 months or more. They said they cannot join political parties for 5 years. Our electoral term is 4 years, and they want to bar them for 5 years. So that's also very excessive. If they do want to bar people who from joining a party who've been jailed for more than 6 months, we feel it should be reduced to maximum of 2 years. Registration fees of $5,005. I don't know why the $5 is there. Well, $5,005 fees and 5,000 signatures we think is too high. Again, it should be reduced to $1,000 and 1,000 signatures. It should always be, people should be encouraged to form parties and not discourage them by making requirements high. And also records of party, they say, it has to be maintained. They said head office plus district officers. And there's a long list of things they're required to maintain at all these offices. So we felt this is too high. These records should be kept, required to be kept mostly just only at the head office. And maybe it should be restricted to constitution of the party and list of the members of the party, for example. Restrictions on donations and advertising. They say only individuals can donate. Well, look at Elon Musk. He donated millions and millions, and that's how Trump won. And of course, if businesses don't donate, how can we expect political parties to win? In Fiji, these businesses, they donate as private individuals, to Fiji First. So they found a way to circumvent their own law, and which is unfair on the other parties who could not get donations in the same way. And the same restrictions apply for advertising, Those expensive billboards by Fiji First. The others, they were restricted to cardboard, boards. for example. They cost a lot of money, so they should be, business organizations willing to fund parties, they should be allowed to do so. Of course, they can put in their audited accounts where they receive the money from. And $100 per day fine, that's when for the providing their annual report. I think that sounds a bit excessive. So I think that also needs to be looked at. Dispute resolution mechanism, they said the Electoral Commissioner's decision is final. I mean, they should allow appeals to court and tribunal. Can't have the decision as final. Recommendations for the fines and penalties, if they're unable to register as a party, they should not be jailed, or made to pay excessive fine. We feel there should be no penalties at all if you're unable to register as a party. Instead, they should be given a maximum of 3 chances to register. First time you fail, you get a second chance. Third time, again, if you fail, second time. But if you fail a third time, you are not allowed to submit a further registration of your party. So that's what we felt was more fairer. So remove Section 4 of the Act. Section 4 says after this Act comes into force, you have only 28 days to register. Well, 2013 happened a long time ago, so that part of this Act is redundant. It should be removed. Yes, so some of my the recommendations, we've already said it already. Yes, those fines, the maximum should really be a minimum, so it does not discourage people. Yes, I think I've already factored in our recommendations. Thank you. I think that was 5 minutes.
Thank you very much. Table number 4. We have any comments from?
A question for our presenter. Actually, on the imprisonment term, you said it's 6 months. Then you cannot stand for the election for.
It says that a person who's been convicted for 6 months or more cannot join a political party for 5 years. Okay, so as you can see now, he has identified as a discrepancy in the Political Parties Registration Act and the Constitution, okay? So this is joining a political party, it's not standing in elections. So there are 2 different things. It says if you've been convicted for 6 months or more, you cannot join or become a member of a party for 5 years. So we felt that was too excessive. If there needs to be a restriction, it should be 2 years. You can't join a party for 2 years, yeah.
Just a question. I know people might not like me for this. But in terms of what I mentioned before about it being a deterrence and a maximum cap, but this part of your statement that the maximum should be the minimum. So do I take it in that the maximum of $50,000 should be a minimum of $50,000? No, I don't know. It's just what I'm hearing. So this is just wanted to clarify that the maximum should be the minimum.
In terms of justice, justice is fair when the proportion of the penalty is in proportion to the crime. Okay, so just for justice to be fair, for a minor offense, the penalty should be minor. Only for a very serious offense, for example, if you've been a serial killer or something, you should be jailed for life. Yeah. Whereas if you stole a bread, you should really just be given a very small fine, for example, like $10 or $50 fine. But here, the kind of penalties we have, for minor offenses, we are getting very harsh penalties. So justice is not served, okay? Rights are being abused when that happens. It's unfair. Thank you.
We have that those penalties, yeah? Okay, for stealing a bread, that would be something that you do outside. Once you go inside government, you'll be looking at billions of dollars. So I think
the floodgates that was created was supposed to protect what you haven't seen, not what you have seen outside. But as soon as you enter government, you'll be managing millions and billions of dollars. So I think if we say draconian, you might say it's draconian, but that is just to protect the people that can steal $1, not to go inside and steal $1 million. Thank you very much.
All right, thank you very much. We would like to move on.
Make a comment on political parties' finances. One of the things that we saw in the last administration is when I don't know how it came out, but there was a list of financial donors. And there's this particular Gujarati family that we personally know. What they did was, I think the head of the family, his name was written as is. He gave $10,000. And for the other family contributors that also gave $10,000 each, they all, the first names were correct, but they changed their surnames. And so we believe the legislation is not fair on investigation on the donors. Why should they be receiving more than from one family, whereas, you know, it's stipulated, it's clearly stipulated 10,000 by one donor. So I believe it's something that should be brought up in the next reform. Vinaka?
Thank you. That's a good recommendation. And
just regarding the 2 years that Madam was saying, I think it might clash with the police clearance because you need police clearance to stand. I think it's about 10 years for police clearance.
There you go. Some very good recommendations and questions coming through. The last group.
Okay, Mbulowinaka everyone. Our group member one has left. We are a combination of USP, Dialogue Fiji, and Methodist Church of Fiji. Strength, we thought Section 31A was good, which is the minimum age of 18 years. So we should keep it. 31B, proof of citizen, is a little bit problematic. I'll ask Sandra to give some examples.
My example is very personal. Proof of citizenship. If you are someone elderly who has been born overseas many years ago, doesn't have any current valid ID, like passport, no citizenship certificate, how do you, and as I said, born overseas, how do you actually establish your eligibility? And it's very difficult, this is jumping a little ahead here, to register, as I've also just experienced recently with my elderly parent, when you don't have valid ID. You go around and around in a circle actually trying to get registered, but you need something valid to do that. And I know there's reason for why you need the valid ID, but when you're old and you're elderly, when you're elderly and you're not very mobile, it's sometimes problematic getting that kind of validation. Thank you.
Vinaka, Section 4, it was suggested that it be included as 4J, after 4J, to include VKB. Not clear. Our member that recommended this has left, so give it the benefit of his absence. And then Section 4.3, supervisor of a registered officer may reject an application that is not completed in accordance with the section. We thought that needed clarification. And then for 4, it's talking about a crime. Person who applies on more than one occasion shall be guilty of an offense. So the fine is not exceeding 10,000, similar excessive. The excessive fine makes the act not citizen friendly. And the question we have is, where is the due process? It's talking about, because the supervisor of election makes the decisions there and then on the spot. Is that a statutory offense where once you commit the offense, you are fined, or do you have to go to court? Do you have the opportunity of going to court later? We looked at the act. There was no provision stating that if you commit an offense under this act, you shall be so and so. And then again, section 5.2, we thought that it was unnecessary.
Explain again. A person who fails to comply with the above section about notifying about change of residential address within 3 months commits an offence. We felt this was unnecessary and redundant. How do you enforce that? How do you even prove it? Again, personal story. My parents moved. Years later, no one actually, checked. So it's something that we probably can do without if we move to the next section, which covers the question of being able to be allowed 6 months to still change, eh? Is that? Yeah. It seems to be some inconsistency. So our recommendation was remove that provision, 5.2.
Section 10A, we thought it was excessive, and 10A talks about manipulation of nominal registration of votes, and we also thought section 11A1 needs to be clarified.
11A on the publication of the National Register of Voters. I think this was one of the strengths of this act, but it might need to accommodate the changes in modes now, so having some reference to digital publication. Yeah.
And in general, we thought some of the weaknesses was that we couldn't find any offense provision, which made us question the fine. So most of these weaknesses we may have mentioned the recommendation. There are some strengths. We said 3A, 4.5, 5.1, and 5.2. And in general, that it is a public document and available for members of the public. We thought that was not one of the major strengths of this act. Unfortunately, at the end, we found that we were missing one page. And we asked for it, but now that the group questioned the validity of this copy, we presented on what we were given. Vinak.
Thank you. Anybody else wants to present? Oh, wait. No.
Yeah. Go in front then.
Okay. Hello. Hello, everyone. I'm Maria Kumar. I'm from USB Journalism. Really want to keep it short. And so most of what we have already written down has been said. But just wanted to mention that registration conduct was precise and clear. Also, not going to be naming, numbering, or anything, just really, really specific, yeah. And the declaration of assets we thought was also a strength. of this act. Here, also, just wanted to say that Manoa could have handled this without me being here, but I'm here anyway. So, something interesting that we wanted to say was these high penalties. We've been talking so much about penalties. We saw them as a strength because it acted as a deterrent to prevent political parties from committing the crimes, from committing the corruption. It acts as, as we had mentioned, that it's a law. And the moment there are laws in place, you risk breaking it. And with it comes repercussions. And so we thought that it did act as a strength because it helped to prevent it before it began, or at least try to. But you will also notice that we added high penalties as a shortcoming or as a weakness as well. And so I'm just wrapping up the strengths. My good friend Manoa is going to elaborate more on why its high penalties are both a weakness and a strength, and some recommendations as well.
So just focusing on the first point of high penalties, just touching on what everyone has been saying so far, but the only thing that I want to bring in that's new is that because our electoral system has been brought over from international best practices, just around the world, I don't think, and I think Alan can correct me if I'm wrong, there's very few countries that implement a prison term more than 10 years for electoral fraud and mismanagement. Correct me if I'm wrong, but I'm just thinking on that line, if we're bringing international best practices, then we might as well also consider the penalties, the fines, as how they are done internationally. Deregistration. This is also a subsection in the Political Parties Act. The fact that if a political party is deregistered, the members who are already inside Parliament, they automatically become independent. And this is what we saw for Fiji First. I didn't vote for the party, but I felt strong, like if the party that I voted for became independent and they joined another party that I didn't like, that would make me disillusioned. It would make me feel that my vote was wasted. So that was a shortcoming. And the recommendations, reassess donation caps, and we also would like to include in the act for political parties to mandate quotas. Thank you.
Thank you. That was very fast. Anyone has any comments while the next group is coming up? Good.
Thank you. What our group has discussed this afternoon in relation to the document that was given is in terms of the general document, we were able to understand it given that we had to share one. And so, some of the strengths here would be the language itself, that we were able to understand the wording and all. Also, the sections are clearly marked, and the headings of each of those are also good for us. We were able to follow it. And so looking into the work that we had to do, we tried to pick up some of the limitations that we were able to work out right away. And so the first one, our group looked at the first section in terms of the registration of a political party. And something we felt that need to be included is a clause that should talk about a political party's existence, that a political party should run at least 2 years in office before it could actually, campaign or run in elections. That was one of the thoughts that we thought would go in there. And then the other one was in section 6, to remove altogether the signatures that are needed. We felt as a group that there's no need to even put fees or to actually have signatures to register that party or a party. And having said that, we also looked at a special question that we'd like to pose to everyone. And the fact that we have a registration of parties, etc. here and a document to guide us, it's all clear and transparent. But we're trying to think, for a small nation like Fiji, how about we just go back to having just 2 main parties and have those parties run and we vote for them? That's just something we're throwing out to everybody. Thank you.
You can quickly ask the question while the next group is coming up. One question, yeah.
Did you mention that a new political party have to be registered 2 years before?
That's their recommendation.
If these documents are also translated, that's something we'll want to put across. And thank you for the workshop. It has actually helped some of us that are attending it to refresh our heads and minds in the things that's happening in the country.
All right, thank you very much. Agatha?
Thank you. Group 5 is back here, and we are this time tasked to look into the registration of voters. Yes, there were 2 groups doing that. We have picked up a few issues that we would like to focus on, particularly on section 3.1. Subject to subsection 2, a person who has reached the age of 18 years and is a Fiji citizen is allowed to register. The question I pose is, you are doing registration hypothetically this year, 2025. Election will be held in, say, earliest is August 2026 or 2027, last date. What about those who fall in between? It would be grossly unfair to miss them out. You should not take 18, those who have turned 18 as the rule now, but they would be qualified to vote when election happens. So you must account for that. The way to do it, go to the Registrar of Births, get hold of all those, visit the schools who are in Form 5, Form 6, and will be turning 18 when the election happens. Account for them. There's a mass population there. Number 2, any person who during the registration period is serving a sentence of imprisonment of 12 months or longer imprisoned by the court in Fiji. This is shall have the right to be registered as a voter. Any person who during the registration period is serving a sentence of imprisonment of 12 months longer or beyond. Why should they be barred from registration? Don't the prisoners, don't they have a political right? It's a matter of voting. Okay. Next issue we picked out from section 3, the supervisor at least once a year publish a notice in daily newspaper and broadcast a notice over the radio. Why limiting to newspaper and radio only? And that too once a year is not good enough. At least quarterly. And must also exhaust all other media. Social media is cost effective and wider. No? And what is stopping them to visit schools? When education is compulsory, all the potential voters will be turning first time to vote will be in the school. So working with the schools will be a very practical thing to do. Then on application for registration, a qualified person may apply for registration. The moment you say a qualified person may apply, clearly shows that it is the responsibility of the person who qualifies to register. We have a full-time Fijian elections office. Isn't it their responsibility? Aren't they paid to ensure that every Fijian who is turning 18 or will qualify to be registered? Why wait for the applicant to come to you? Why can't you have a similar system? You outreach those who will be eligible to vote. So equally, it is their responsibility to outreach to them, and rather than just waiting for the application. Number 2, an application for registration as a voter shall be made to a registered officer. Again, not an application made, It's your job to also ensure you are paid to do the job, ensure that all potential voters are on the register. Then on section 4, subsection 3, a supervisor or a registration officer may reject an application that is not complete. Come on, you have all the time to do the register, and if application is not complete, what it takes to get it completed? Why leave them behind? For little one piece of information missing, you leave it, now deny the right to vote? I think it's not fair. Include. Number 4, a person who applies on more than one occasion to be registered as a voter shall be guilty of an offense and liable under conviction of a fine not exceeding 10,000 or a term of imprisonment not exceeding 5 years. What if the application was made and then lost, and I go 2 months down the line and I find out my application is not there? Then I apply again. 6 months down the line, there's 2 sets of application there. Should I be penalized? We must look into that. Yeah, there are other issues. We leave it there. Thank you once again. All the issues that I haven't picked up, take it as a strength, it's acceptable. And a recommendation is given.
Thank you very much. And that was the last group. The last group that was meant to go and said that's okay, everybody has covered it. Anything from anybody? Any?
Thank you. For me, it's just a suggestion, something that I've been thinking about it for the past 2 days. I mean, the whole government, stakeholders, everybody is talking about electoral reform. There's a lot of workshop not only done by the dialogue, there are other organizations as well. The commission have been going around. But something that we need to look at is the highest number of people not turning up to the voting day, which are the youths. What way we can identify stakeholders, everybody, what way forward that can be done to get the youths to actually come to the registration point, to actually come on the day of voting. How do we get them? Because if you see the results from 2014, 2018, 2022, released by the Fijian Election Office, it's always the youths that, I don't know whether they are not interested in this, or do we have a lack of somewhere, the meeting point that we need to come up with in order to get the youths to be more involved in this. I think moving forward, if we can only work together from political parties, encourage your own family, start from your own family, your own people, start from the ground. If they are in Form 6, Form 5, if they are in your family, encourage them. There's a way forward, and if you can go and register, encourage them. So the way forward is for the youths to get registered and go there on the voting day. Thank you.
Thank you very much. Definitely worried about the right group. One last comment? Two comments, okay.
I would like to make a point here because we're actually on the ground. And this is not here in Vitilevu, but this is in Vonualevu. What I have found out that there are a lot of people, especially in the village areas, that do not have voter registration card. So I believe that, as the young man had said, that we need to do a lot of voter registration awareness. We have the time. And also we need to be working with the election office As we go out with them. I'm sure they're making an excuse of this, like the budget. If we can come up with other suggestions of going out to the rural area, to the villages, so that we can help those that haven't been registered, it should be a great effort from all of us that are here. Vinaka.
Thank you very much. And for the very last point, yes.
Your answer, I think it's here. It mentions about the youth of Fiji. That's from Group 9. Thank you.
Thank you very much, Group 9, for including the youth of Fiji.
And just to add, I think the timing of the general elections, it's towards the third term of the Form 7 or Form 6. That's 18 years. That's a very important time of their studies. If they focus on their studies at that time, they will not concentrate on the voting. They will concentrate on their career. The last stage of their studies is to pass the exams. If you can see that timing of the elections. First term, second term, okay. But third term, you are actually pushing them out because they are focusing on their final exams, which is very important to them. Thank you.
That's a good observation. Thank you very much. Is there anyone else with any observations, or Mr. Alan Wall or Mr. Nilesh?
Just a observation on the timing of elections. It is the prerogative of the government of the day to announce the date for the election. Election happens once every 4 years. And this is total abuse of their prerogative to hold it till the 11th hour when the writ is filed, then we know the election is around the corner. Why can't we set it in the annual calendar, come when election falls due, that this month we'll be bracing up for election? What is there to be secretive about something that is known to the government of the day and not to the public at large? It's an extremely important event, and I strongly urge authorities must pursue this and demand that we all know the date, the year, and the month in which it's going to fall as we embark on it. Thank you.
Thank you, Mr. Kumar. That's good for holding the people responsible. Oh, we've got a few hands coming up. Oh, oh, in support. Okay, thank you. Right. Amelia.
Just from my observation, 4 years is a long time to prepare. I think the thing that we need to do is to change our mindset. The mindset is the problem with people nowadays and their choices. So with the youths, you have to understand what sort of mindset that they have that is preventing them from wanting to vote. That's all I want to say. Thank you.
Just something on, so I'm part of the National Youth Council, and something I'll just put it out here, that when you are taking, or even for the organizations here, individuals here, if you do not decide to wait for the FEO and decide to go down to the community level, to the village level, and advocate for your civic rights, for voter education, and advocate for other parties, just make sure that you are mindful that some of these youths do not go through the formal education system. And they still are 18 years of age, and they have the right to vote. And they are asked to come into the polling venues and vote for something they do not know. So this is why, and we have seen this through the National Youth Council, that people come and tell us that we do not know whom we are voting for, what we are voting for, what this person stands for. I don't know that person. I'm just going there and I'm just going to make a tick, cross, or circle. Because whatever we see on TV or whatever they come and talk to us about, whatever they say, it's too much legalese, too much complicated language. Right? We do not know what this particular word means. So if you are going there, you're explaining the voting process, or if you're going there with the political parties that are here and the upcoming ones, if you want to go down to the village level, get their votes, urban youths, the ones that are here, they go through the education system, but those that don't go through the education system and they need your support, explain it to them in simple language. Don't try to be smart, right? You walk with them. Don't try to make them walk for you. Encourage them, right? Don't keep them in a cloud of haze and illusion. Always work with them, try to make things simple for them. The simpler, the better. Thank you.
Thank you very much. And with that, that was the last question, the last observation. Thank you. Direct to the heart of Ellen, would you like to give an observation?
I've talked enough this last couple of days. What I would like to say, though, it's really obvious that the shorter law, the Voter Registration Act, attracted the most detailed observations, and there are some really good observations on how the mechanics of that can be improved to make it easier for people to register to vote. Just a couple of international things. The barriers to party registration in this country are high, about the 10th highest in the world when you compare them to what you have to go through to register a party here. Very much higher than most parties, both in terms of the money and in terms of the number of signatures. So that's something that you might want to consider in an international context. We've talked enough about penalties. This concept of going back to two main parties sort of goes against the concept of having a pluralistic party system. And I think that would probably be a difficult thing for Fiji to go back to. On the party law, there are political party law. There are obviously things that the political finance part of it isn't dealing with well. Now, political party finance law is a bit like tax law. The more you regulate it, the more loopholes high-paid lawyers will find in it to be able to make sure that their donations get through. So you have to be very, very careful as to how you frame any changes to political finance law, so you're not just creating more loopholes for people to go through. And that's about it. It's been a great discussion. There's been lots of really good ideas coming out this afternoon as how things could change in the law. And hopefully Dialogue Fiji will be able to synthesise these and this be truly a method of people being able to... It's not as bad as sitting on stage with 5,000 watts of amplifier behind you doing that, I can assure you, and that's happened to me before. Hopefully Dialogue Fiji will be able to synthesise this so the voices of these people, all of you here, can get through to the Commission. And this will make it a very worthwhile 2 days. I'd thank you as a guest here for all the incredibly informed discussion that we've had over 2 days.
Thank you very much, Ellen. And with that, we conclude that particular session. I'd like to ask our director, Executive Director for Dialogue Fiji, Mr. Nilesh Lal, to give the closing remarks and the final synthesis.
Thank you very much. I'd like to thank you all for staying until the end. These 2 days have been fruitful on several counts. What we're going to be doing next is we'll do a consolidation of the recommendations that have been made, and essentially, all the proceedings that have happened. We're going to make an account of it, and we'll do a concise report that will go to the Fiji Electoral Law Reform Commission. At the end of this month, the Law Reform Commission is going to be releasing its own report. So we will see whether we'd be doing a follow-up event like this, maybe in the next 3 weeks or so after that report comes out. Right? We've also put some questions in the evaluations that we've done. I hope you're able to complete and return it to us, which has questions about, what do you think ought to be included in subsequent interventions that we do in relation to electoral law reform. Once again, thank you very much to all of you for attending the 2 days event. I'd like to sincerely thank Mr. Alan Wall for coming from Australia at our invitation. Also for Professor John Frankel. I'd also like to thank all the speakers, resource people and others that spoke and contributed to the event. Thank you very much once again, everyone.
Thank you very much, everybody. With that concludes the 2-day multi-stakeholder dialogue. We do have afternoon tea for you to have some light conversation and de-stress. If you haven't handed in your evaluation forms, please do so to the team, any of the team members. And we'll see you in the next forum.